morning, ladies and gentlemen. I am Dr. Naresh Sharma, Deputy Drugs Controller, India, CDSCO. With great pleasure, I welcome you all to the training program for the Drug Inspectors, Assistant Drug Controller, and Deputy Drugs Controller of CDSCO on powers of arrest and seizure under BNSS, Drugs and Cosmetic Act, and recent Honorable Supreme Court judgment in the Union of India versus Ashok Kumar Sharma. This program is hosted here at NIHFW Munirka, represents a crucial step towards the strengthening and enforcement capacity of legal preparedness of our officers from CDSCO. We are gathered today in a beautiful green campus of NIHFW, a national institute known for its excellence in the public health training and capacity building. CDSCO India's national regulatory authority continues to work tirelessly to ensure the quality, safety, efficacy of the drug and cosmetic across the country. And what a better place other than important program for this is Delhi, a city where historic governance and modern regulatory institutions comes together. Ladies and gentlemen, now we are going to begin the inaugural ceremony. It's privilege that we are having chief guest Shri Ravi Joseph Loku sir, IPS, additional. Sir is Additional Director General, BPRD, New Delhi. Our guest of honor, Dr. Sunil Vilas Rao sir, got the parliament session at the last stage, so he is attending that important meet, so we are going to miss sir, but his blessings are always with us. We are here, Dr. Rajesh Kumar, Professor and Nodal Officer from the NIHFW, and Dr. S. Ishwara Reddy sir, Joint Drugs Controller India, from headquarters CDSCO. This training has been conceptualized under the dynamic leadership of Dr. S. Ishwara Reddy sir, with the objective of strengthening legal, procedural, and enforcement skill of CDSCO officers involved in the arrest, search, seizure operations. Over the next 2 days, experts from the judiciary, enforcement agencies, and senior regulatory officials will guide participants through the practical demonstration, case studies, and legal interpretation. For the welcome address, I request Sri Sushant Sharma to welcome Shri Ravi Joseph Loku. I request Shri A. Sankathe sir to welcome Dr. Rajesh Kumar sir. I request Dr. P. Malavalan to please welcome Dr. S. Ishwara Reddy sir. I request all the dignitaries on the dais to please join the lighting of lamp for formal inauguration of this training program.
सरस्वती नमस्तुभ्यं वरदे कामरूपिणी विद्यारम्भं करिष्यामि सिद्धिर्भवतु मे सदा
सरस्वती नमस्तुभ्यं
I invite Dr. S. Ishwar Reddy, sir, Joint Drugs Controller India CDSCO, to deliver the welcome address. Please, sir.
Respected Shri Joseph Loku sir, Additional Director General of Police, Bureau of Police Research and Development. There is a BPRD organization in New Delhi, mainly responsible for developing various modules, standard practices for the investigations. Just now we missed the Dr. Sunil Visal Rao, who is the Director for the NIHFW, Dr. Naresh Sharma, Dr. Rajesh Kumar, Professor and Coordinator for the CDSCO training program. All my dear participants, those who have joined offline and online mode, very good morning to all of you. So, there is alternative procedure for good morning is the claps. Oh, very good. When I say good morning, very good morning to all of you. Oh, this is a winter, I can understand, energy will come less. Say good morning. Thank you so much. So in fact, our DCJs are supposed to join for the inauguration, actually who is the backbone for designing this program and also the development of conceptualization of this entire program. We really miss him. So first, I on behalf of CDSCO, NIHFW, it is with great pleasure to warmly welcome you all to this training program on powers of arrest, seizure under BNSS, Drugs and Cosmetic Act, and recent Hon'ble Supreme Court judgment in Union of India versus Ashok Kumar Sharma. First of all, let me thank Enforcement Division of the CDSCO, who really recommended training cell to organize this training program for all CDSCO participants. In fact, this concept is not from the training cell. This is recommended by the Enforcement Division. Various topics, whatever we are covering in this today's training program, the topics also suggested and recommended by the Enforcement Division to organize this, not only for the drug inspectors. They specifically mentioned in the recommendation that this training program should be conducted for all deputy drugs controllers, assistant drug controllers, and the drug inspectors. That is the reason if you see the participants here, we have all senior officials also as a part of this training program. In fact, I suggest and really we also encourage and appreciate other divisions of CDSCO also will suggest what type of training or what type of sessions you required for your specific to your division. Instead of we identifying the topic, we identifying the sessions and including the speakers, if the proposal comes from your concerned division, that is going to be really useful for you. In fact, one of the parameter for the NRA assessment is also clearly says that how you identify the training needs. By sitting here, if I imagine and something will develop the training needs, it may not be really suitable for you. So I request all the divisions of CDSCO, including zonal, sub-zonal offices, kindly suggest what type of issues, challenges you are facing on the field. And you suggest the topics accordingly. So in all our future training programs, we will include such type of sessions as per your request. We are very grateful to Ravi Joseph sir for accepting our invitation and becoming a chief guest for today's event. Thank you, sir, for your presence here from your busy schedule. Sir has also helped us in suggesting few speakers' names for our topics through their staff, Ms. Chaya Sharma, who is the Inspector General in charge looking after the training programs, and also she is the director training BPRD. And we are grateful to you, sir, for suggesting the good speakers for the various topics. I would like to also to express my gratitude for the continuous cooperation and support of the director NIHFW and entire team, especially Dr. Rajesh Kumar, for providing state-of-art facilities to conduct this training program smoothly at very short notice. As you are aware, at present, in India, we have 2,283 drug regulators. This is including both state as well as the CDSCO. Out of 2,283, 379 officials are from CDSCO. At present, working officials. I'm not talking about the sanctioned strength. The sanctioned strength of CDSCO is 792. Out of 792, 543 officials are meant for the matters relating to drugs, and 249 officials are only for the medical devices. And at present in the state drug regulatory system, we have almost 1904 drug regulatory officials across India. Why I am giving all these figures about the strength of the regulators in India? Reason is, till now, the training cell, we have imported training to 2,149 drug regulators in a period of 2.5 years. That means we almost trained each and every inspector at least once on various specific topic. We almost covered all regulators in India by inviting them, and at least one training program they have attended. We conducted 32 residential training programs at NIHFW, wherein 1,442 participants are attended only from this NIHFW campus, and 9 regional training programs, wherein around 672 officials were present. We also conducted 20 regional workshops on various various sessions, especially on Schedule M as well as the medical devices, wherein we have almost 40,000 industry representatives were present through offline and online mode. And as you are aware, we are also in the process of developing e-training modules. Already around 20 modules have already been developed. It is already hosted. It is yet to be launched. And what we also did is, whatever trainings till now we have completed, so we have almost 900 presentation PPTs on various topics. So we are already posted all these 900 PPTs on the portal, that is NIHFW portal. They have a LIMS, and we are waiting for the inauguration of this portal. And once this portal is inaugurated, all the e-training modules and all the 900 PPTs will be available to all the regulators. We already collected all the regulators of India, that is both the CDSCO and the state authorities, their emails and mobile numbers. So this portal will be accessed only through the login credentials. So in fact, if you see, this entire credit goes to the training cell. That's why I am very thankful to the entire team of training cell, especially Dr. Naresh Sharma, for his active contribution for successful completion of all programs. My special thanks goes to Dr. Rajesh Kumar also for his continuous support in organizing these programs very smoothly. The main, as you know, if you see the, coming to the objective of this training program, if you see the training module, I think a soft copy we will provide to you in the WhatsApp group. This training program mainly to enhance the legal, procedural and operational competence of CDSCO officials in exercising their enforcement powers, while ensuring compliance with the Hon'ble Supreme Court judgment in Ashok Kumar Sharma case. In fact, this Ashok Kumar Sharma judgment written by Justice K.M. Joseph, who is a former justice from the Supreme Court. In fact, we tried to invite him as a speaker to share his real experience. But unfortunately, he is in Kerala, that's why he is not able to attend. In fact, we also tried to invite the Justice S. Nagamuthu, He is also ex-former Madras High Court judge, and who is the amicus curiae, appointed by the Supreme Court for this case. Amicus curiae means the person who can assist the court for for suggesting what are the issues, challenges, and what are the remedies for that. So Mr. Nagamuthu was appointed for this. He is from Delhi only. We invited him. In fact, initially he is accepted to come over here, but unfortunately because of last minute other engagement, he is not able to join. What we're trying to say that we try to identify the best speakers, including those who have really given the judgment of this case, and really those who, and also we have invited the Pinky Anand, who is actually who was the additional Solicitor General on behalf of Government of India for this matter. So she is joining today. So friends, if you see the training modules, we try to invite the best speakers available from police, judiciary, regulators, and other agencies. And you can also see the program. We also have case study wherein our inspector first time who arrested the person, I think Rakesh, and other inspector also from the Haryana Drug Control Department, we also invited them to share what issues, challenges they have faced. So in fact, at the end of this program, what we'll expect from you is that you are going to having the adequate knowledge on the legal framework for the investigations and CRPC and BNSS and arrest and search procedures, what documentations to be made and collected, and how to do audio-visual recording during the search and seizures. And also how to collect the digital evidence and what are the rights of the accused and how we can have the interagency coordination. So this is what we possible expected outcome from this training program. So before I conclude, CDSCO would like to engage with BPRD for the sharing of best practices developed by them. In fact, I have gone through their website. I request all of you, please go through the BPRD website. They developed a very good criminal manuals for each and every type of crime. And even we will share you today, even they have developed a SOP for audio, video recording during the search, seizure, and arrest. It's a very good SOP. So which will be very useful for us. Sir, we'll like to engage with you for sharing of the best practices which will be useful for us. So with these words, I once again warmly welcome you all for this training session, and very happy learning to all of you. Wishing you world of knowledge. I am sure end of this 2 days training, you will carry the adequate knowledge with you. So as quote says, may this learning journey bring you closer to achieving your professional goals and enhancing your regulatory expertise. But one quote of the robot I will always like that, I never learned from the man who agreed with me. Generally in our system, we always, whatever boss says, yes sir, you are correct, you are very fine, you are very intelligent. And you always agree with the boss or subordinate. The moment you agree with everything, you never learn. Always there should be a scope for the discussions. That will definitely improve our skill and our knowledge. Thank you very much for your kind attention.
Thank you so much, sir, for your insightful address. We are truly honored to have with us our chief guest, Shri Ravi Joseph Loku, sir. Sir is IPS from 1995 from Uttar Pradesh, and he served as Superintendent of Police in the various district and DIG of Azamgarh and Prayagraj range, headquarters in Uttar Pradesh. He also served as Inspector General in BSF as well as NDRF. Sir also served as Additional Director General of Police in the various capacities in Uttar Pradesh. Sir also have been awarded the Police Medal for the meritorious services in 2011, various prestigious capacity for the Uttar Pradesh, as well as he also have been awarded for Utkrisht Seva Padak in 2020 and President's Police Medal for Distinct Services in 2021. At present, sir is serving as Additional Director General, BP R&D, MHA, New Delhi. Please welcome Shri Ravi Joseph sir.
Respected Professor Rajesh Kumar, NIHFW, respected Dr. Ishwar Reddy, Joint Drugs Controller, CDSCO, and all the other officers of the CDSCO and dear participants. It is really an honor for me to be here because I never addressed other than police officers as investigators. For me also it is a different and new experience to interact with you and to see you face to face, whereas investigating officers you would be performing your duties in a legal framework. Yeah. So as sir has mentioned very clearly that what are your responsibilities and in what area you would be working. As a police officer, I have now put on 30 years of my experience. So I would like to say that there is a vast difference between the regulating authority and the investigating authority. So, but good to see that the both the realms of the work, they converge here, and your regulating authority as well as investigating authority. So what challenge now you are facing, that recording of the audio visual recording of the seizure and search, it is not new to you, it is new to the police officers also, because it is. So don't get puzzled that how to go about in the investigation. Equally the police officers are also puzzled because till now whenever there is an arrest, it is only you have to have two witnesses and then you arrest a person, arrest memo is there, and then they take into the custody. So nobody must have, no third person must have watched that arrest. It must have been done in a very confined area where there is no evidence to prove that the arrest has been done in a rightful manner. So it has happened for all these years, like till 2024. At the same time, when we are, when you do the seizure, that is also, one can just implant the things, and then I have seen as a police officer, my role is not that they are, not that a particular section should be applied, or not that something is being followed. I have to see that whether they are doing the malpractice in this or whether they are violating the procedures. That was the main cause for me, because all human rights complaints, all other strictures which come to the police is not complying the proper procedure. Like if the person is arrested, we don't know. The person is arrested, and you all know the stories that the person would be there in the police custody without any documentation for days. एक दिन अरेस्ट करके लेके आया है तो 7 दिन तक उनको बिठा के जो करना है करते थे. So there is no any evidence that yes, he has been arrested at the particular time, and now actually it is only 24 hours he should be there in the police custody before getting an extension or before handing over to the judicial custody. But there is no, one cannot prove that the people used to come to me, the father or the mother or the wife or the children, saying that कि सर आपका इंस्पेक्टर साहब हमारा बंदा को कल लेके आए थे, अभी भी बिठा रखे हैं, 4 दिन पहले लेके आए थे, अभी भी बिठा रखे थे. So there is no proof to actually take action against my inspector. But now in 2024 BNSS Act, so even the arrest and everything need to be recorded. So this digital age and the digital interference or digital intervention, so that really made the things very transparent. Transparent, the word and the phrase and the philosophy is very crucial to this 2024 BNSS Act. Transparent, scientific, and time-bound. So these are the three phrases, and citizen-centric, the fourth phrase. So these are the crux of the philosophy of this BNSS, which really activated the spirit of the police also to guard against the irregularities which are being followed.
even for the seizure also, there are lots of mismanagement. And I have seen one case in my police thing that a person really got, but at the verge of the conviction, but had I not intervened, he would have really got convicted, because it is a crime scene and it is a robbery. And and the person, you know that police, mostly, I don't want to say it on record, mostly sometimes police want to, just to solve the case, they sometimes end up arresting a wrong person. So, but this in BNSS Act, you can't do that. And then during the seizure, they obtain the fingerprints of that person and then produce those fingerprints, saying that these fingerprints have been found at the scene of crime. So when there is this much strong evidence that you are describing the scene of crime and you are saying that I have lifted the fingerprints from the scene of crime and these are the fingerprints obtained in the scene of crime and these fingerprints are matching with this person, so this person has committed that robbery. So who is going to refute it? Because everything is done under the eye of a police and no other person except the two witnesses sometimes who are in connivance with the police officer. So certainly when it goes for the prosecution, the person will be convicted because the document says that these are the fingerprints which have been lifted from the scene of crime, and here the scientific expert, the forensic scientists are saying that yes, these fingerprints which are taken from this accused are matching with that, and you are also proving that yes, this fingerprint is of this person. So how can that person really escape the clutches of the law? He cannot. He will be convicted. So the onus and the responsibility, the noble cause which the police need to be worked, that has been compromised. So in order to bring the transparency, this recording of the audio-visual recording of the arrest, seizure has been introduced, which is also like for police officer also it is a new thing. So how the police officers, now the senior officers, how they ensure this new provision which has been given in this BNSS. One thing is that to make the things transparency, that is good. But recording, the audio-visual recording itself is a digital evidence. So there is another angle which has come into this one is digital evidence. So how to handle the digital evidence? Now, even our police officer also really at confusion or loggerheads how to go about it, because they have to use the mobile phone and the mobile phone should be it should be having its integrity. There should not be SIM card in it, and then when you record it, there is a hash value also. That hash value need to be recorded so that you have to prove yourself that you haven't tampered that recording. There are lots of things which again attracts the law related to the digital content. So the challenge has become now twofold. One is not only recording it in a transparent manner, but also proving that the recording which you have done is actually having that integrity of its content. So I'm glad that you, sir, has taken an initiative that you need to be trained, and I would like to invite your participants to our institutes also. There is a Central Detective Training Institute in Ghaziabad, so which is nearby. So if you want more intensive approach in this kind of investigation, seizure and arrest, so we have modular approach. Yes, I have seen your thing very well curated, but BPR&D has come up with an approach of andragogy. Andragogy means that it is different from the pedagogy. College में जो बताते हैं, school में जो बताते हैं, it is mostly like a lecture mode. Like what I am doing is a pedagogy. It is not an andragogy. So उनको सुनाते हैं हम, ये है वो है करके बहुत कुछ सुनाते हैं. But learning doesn't happen in such manner with the adults. Adults के पास ना उनके पास experience है, उनके पास opinion है, उनके पास knowledge repository है. तो कोई बंदा यहाँ खड़े होके अगर आपको कुछ भाषण सुना दिया, तो adult mind it doesn't accept it. they want an experiential learning. So BPRND has come up with this kind of approach where there will be an experiential learning and a modular approach. मतलब लॉ पहले तो केवल लॉ के बारे में बता देता, ऐसा नहीं है कि लॉ का कंपोनेंट्स भी लेंगे, प्रोसीजर का भी कंपोनेंट्स लेंगे, एक्सपीरियंशियल लर्निंग का भी कंपोनेंट लेंगे, उसको एक मॉड्यूल बना के टीच करते हैं. So if you want to have that kind of approach, so please approach BPRND. So we would certainly like to extend the thing. I don't want to give the intricacies of the entire investigation and other things, because your module and the speakers who are going to come, they are going to give you the great insight into these things. But I just want to say that when you got the power of arrest, it is actually interfering with the dignity of a person. And I have seen that most of the police officers got punished because of this. An illegal arrest or arresting in a manner which is affecting the dignity of a person. So please dwell into the philosophy of the arrest, how to do it, how transparently should be done, and how the dignity of the human should not be interfered. So for this, I hope there are so many SOPs are there, but you also go through this and always keep in this point when I am arresting, so am I doing it right manner, and whatever provisions for that key, to whom to inform and to whom to involve and what are the witness, all these things, it should go into your mind, it should be hammered into your mind, so that you will never commit any mistake, because now everything is being recorded. Earlier it was not there. When we are going to arrest, we used to use some reasonable force also, and that was never recorded, but now everything is being recorded. So one should be very cautious, very respectable, and following the SOP. That is one thing which I want to say that. And the second thing is the Seizure and videography of the crime scene. That is very important. That we have a separate module for that, which is a one-day module, how to video record the crime scene. It is not just like taking the photograph. You need to involve the entire crime scene in a manner that nothing is missing. The crime scene should be speaking itself when the judge sees it. So how to record the crime scene is another subject. So I request sir also to give them the exposure, how to record the crime scene. That is a separate section also in the BNSS. So all these things need to be done. And I am glad that I am interacting with you people, and with the hope of that I will be having a future engagements with this institute in collaboration. And thank you very much for giving me this opportunity, and wish you all the best. Yeah.
Thank you so much, sir. And we learned that to accomplish great things, we must not only act but also dream, and not only plan but also believe. Thank you so much, sir, for your inspiring address, and whereby cited to work with transparency and basic parameter to be considered while handling the digital evidence.
No, I would like to say that if you people want you have any questions, you want to ask me anything, so before concluding, that forum is open.
So whatever issues, challenges you come across during your investigations or seizures, this is the right opportunity. See, this is the kindness of the chief guest requesting, open for question and answer. We are very thankful to you, sir. Yeah, please, Bharadwaj.
I am not an expert, but still I will try. Try. What do you mean by wrong arrest? Arresting a wrong person, or
Yeah.
the procedure was wrong? Wrong. There are two things. Wrong arrest means. I understood. So, wrong arrest have two aspects. One is arresting a wrong person. Second thing is the procedure itself is wrong. Both are there. There is a procedural flaw is there, or totally a wrong person has been arrested. So if the wrong person has been arrested, that is a part of investigation. The part of investigation, there comes the investigation is not just a 2-3 sections. Investigation is a logic, common sense, and inquiry. All these things are very much needed in the investigation. Like if any person is wrong person is arrested, so I should use my common sense also. Ki whether is there any probability of this person being there at that place? समझ में आ रहा है ना कि see see anything like domestic violence है, domestic violence में आप कोई पड़ोसी को arrest कर लिया, तो it is very clear that कि अब domestic violence का मतलब उनका घर में, उनका अंदर कमरे में मारपीट हुआ होगा, वो वाइफ एंड हस्बैंड के बीच में हुआ होगा, नहीं तो सास और बहू के बीच में हुआ होगा. बट मैं कही बगल का बंदा कोई है, उनको भी अरेस्ट करके लेके आए हैं, तो देन आई सेड दैट कि मतलब इनका मतलब वाई ही सेड कि नहीं साहब उस समय ये बंदा भी वहाँ अंदर था, ये भी उनको पकड़ लिए थे, झपट लिए थे. Even though the inspector says, but my common sense should be prevailing over ki, is it possible at the night at 9:30 when the incident took place, whether this person who is a neighbor has anything to enter into their bedroom or their drawing room and involve in the domestic violence which is being committed on that victim. So, एक common sense की बात है. And second thing is कि when the person says that, so many things, because the people used to come to me and saying that sir इन्होंने मुझको अरेस्ट किया था बट मेरा अटेंडेंस देख लीजिए, मैं उस समय वो कॉलेज में था, नहीं तो आई वॉज अटेंडिंग इन द ऑफिस, देयर माई बायोमेट्रिक एंट्री इज देयर. सो it is clearly coming to this, that okay, this person is wrongly arrested because at that time actually he was not there. There is an evidence that he is somewhere else involved. So that is also an indication that when they come to the superintendent of police, they say that okay, he is wrongfully arrested. So it is also a common sense, and there is a technical evidence also. So like that, for everything you have to logically think, and sometimes they arrest minors, like 10-year-old boy, who might not be involved in that. So all things wrongful arrest, one can elicit it. Yeah, thank you.
Yes, Kashi.
So how police the electronic data, that is the AV recording, it will be a very challenging task for first of all collecting the data, then storage, maintenance and retrieval to produce in the court. How to manage these challenges and how department is doing that
You
equation?
will be having a separate session for this, but still I would like to answer your question. Electronic data, पहले भी please be seated. Electronic evidence is not a new thing. It was there in the old act also, but not this electronic data which is recording the scene of crime or recording the seizure and search. There was digital crime used to be there, cyber crime used to be there. So we used to go and we used to take the evidence and hard disk se we used to take the data and keep it in our pen drive or this one, and then we preserve it and we store it, and then we produce to the magistrate or whoever is the judicial authority. So this procedure was there also, like 15 years back also it was there. The procedure would be same for this also. There you are extracting the data and you are preserving it, you are storing it, and you are maintaining the chain of custody, and then you are producing to them, showing them that the hash value has not changed. Hash value must be knowing. If you don't know, the people, the next session they would be. So now it is the same procedure. Now also they will follow, but here instead of it is not dealing with the extraction of a data, it is a recording of a particular scene that becomes a data for you. So then the same procedure will be followed. But there are checks and balances and other things. But I would like to mention that in our police thing we got an e-saksh. तो सर उसमें जो भी स्पीकर आते हैं तो उनको बता देना कि ई साक्ष्य के बारे में बताने के लिए ई साक्ष्य एक्चुअली address all your concerns because it is a NIC developed tool which is it is an app which is downloaded in the mobile and then you just operate that app and then all your things that everything is taken care in that and you have to just upload into the thing. Another good thing about is you may also come up because now we have investigating officer, we have a CCTNS. CCTNS is a system where like if you ask me to just you gave me something valuable thing and you asked me to कि इसको अपने पास रखे जब ना कभी शादी में जाते हैं तो कोई हमारे हाथ में कुछ ऐसा ज्वेलरी दे देंगे संभाल के रखना है इसको करके बट वो पर्सन ना जब तक शादी होता है वो टेंशन में बैठे रहते हैं कि ये मेरे हाथ से खो ना जाए करके बिकॉज व्हेन यू बिकम द कस्टोडियन ना तो यू आर रेस्पॉन्सिबल एंड ऑलवेज द टेंशन वुड बी ओवरिंग ऑन यू बट द CCTNS is that the moment you take that evidence, you can just directly send it to the CCTNS portal where that is stored there. तो फिर आपको टेंशन नहीं रहता कि आपके यहाँ जो है वो it may get erased or it may get tampered. So sir, you can also think about this system for your investigating officers. They should be relieved from this burden that they are the custodian and they have to just hold it like a बच्चा लेके जाते हैं ना कि इसको संभाल के कैसे मैं रखूं so that is another system which we have done that immediately through e-saksh it would be uploaded to the CCTNS and CCTNS it is forever there and that CCTNS can be opened by the police office supervisor officer and he can also see what evidence he has just uploaded and the judiciary officer also can see that and prosecuting officer also can see that. So all the verticals are, it is in the ICGS. It is called the Integrated Criminal Justice System.
So this is like a DigiLocker type?
That I don't know, sir. Okay. I can't because I don't have the full knowledge of DigiLocker except traveling with Munirka. So maybe, I don't know. So maybe the subject experts when they come, so you can ask them. CCTNS is only for the police officers. You can ask. You can make a request to the DG NCRB, National Crime Records Bureau, and you can. I think it may be extended to maybe other investigators, maybe NCB officers if they are doing. So the same can be extended to you people also.
Conducting various training programs for digital evidence and digital documentations वगैरह.
Yeah.
In case any CDSCO officers want to join this training schedules and
case
hand-on
any-
practice, can we participate?
If
Because
CDSCO
most of the
officials would
time
like to join the
they
training
include the
programs,
police
right.
officers and judiciary officers.
Yeah. Sure. It is open.
What will the procedure? So we
Right
can
to
apply. Sir.
BPRND. Right to BPRND.
Okay, sir.
And we can direct the CDTH Chandigarh to take the other participants also. It always happens. It is not only we are conducting for the police officers. Sometimes it is for the police officers, forensic scientists, prosecuting officers. So it is cross-pollination. Always happens. So you can also join.
Okay.
Yeah.
Thank you, sir.
But see the calendar of the CDTH Chandigarh,
Yes,
which
sir.
is on the website.
Okay.
And when that particular course is there, you can request the DG PPRND and we'll certainly allow. We'll be glad to make more
Yes, sir.
participate.
Thank you, sir.
Take mic.
Sir, does citizen also have a right to record or so-called accused person also have a right?
Right to record what?
The incidents.
See, I would like to ask one question. Does the citizen have the right to arrest?
No.
Does the citizen has the right to arrest?
No.
Yes.
Yes or no?
No, sir.
Yes. If the citizen has the right to arrest, so I don't say that he has a right to record, but if he record anything, it will not be having any evidentiary value.
Okay.
See, for everything, there should be a value, evidentiary value. If I sign a document, me being in that position, my signature has a value for that document. And some other person signs it on the same document, same information, but it doesn't have a value because he is not the right person to sign. The same thing applies for the evidence collection also. If a police officer records it, it becomes an evidence, it has an evidentiary value, admissible in the court. If the private person records it, it doesn't have that legal thing unless the judge takes cognizance. Sometimes they call कि अच्छा आपका भी recording लेके हम देखना चाहते हैं. Yeah, that's all.
Thank you, sir.
Yeah, great. Okay.
The last question.
I have to leave.
Yeah, that's right, sir.
Yeah. I just want to ask you ki, where this detain has been defined in
Not
BNSS.
defined in BNSS, but it's procedure.
So then I'll tell you. Okay. Because if it is a legal term, so it is self-explanatory. Detain can be just for the sake of, like now we don't arrest a person. First we call him and we talk to him and we get satisfied that okay, he has committed this one and now I am having a conviction that the person has done this. So then the arrest procedure starts. So from then onwards, the arrest timing starts. So from then onwards, called as an arrest. Before that, yes, you can say that for the sake of eliciting an information, for the sake of clarity, if you ask a person to stay at one place, whether it can be your premises or it can be their own premises or it can be any other place, if he is engaging with you for a particular time period, maybe it can be called as a detain. Yeah. It doesn't have any legal this one. Yeah. And whatever you have recorded is a very confidential, so you should not go outside.
No.
Yeah, thank you.
So it's great to have wonderful question answer sessions with sir offering valuable insight and a rich experience, rather practical experience which sir has transmitted from the dais. Now I request Dr. S. Ishwara Reddy sir and Dr. Rajesh Kumar sir to kindly felicitate the chief guest Shri Ravi Joseph sir.
Your first time you are visiting our institute. Great.
Thank you.
To formally express our gratitude, I invite Dr. Rajesh Kumar sir, professor from National Institute of Health and Family Welfare, to kindly give the word of thanks.
Thank you, Dr. Naresh. So, first of all, I would like to thank Ravi sir, who has accepted the invitation and who have came here and addressed our participants. Sir, in future, we hope from NIHFW also, we do a lot of trainings for these, as I discussed, for the paramedical forces, medical officers and all. If something is required, we will be coming to you, sir. Thank you very much for coming and gracing the occasion. Thank you. I would also like to thank Dr. Ishwar Reddy, sir, the Joint Drug Controller, and his team, Dr. Naresh Sharma, and all the team of the training cell at CDSCO, who are working very hard day and night and making these events successful, whether it is having good speakers and arranging all the things. So I thank the training cell team. I would also like to thank my team from NIHFW, Dr. Vikram Singh, who is always there with the CDSCO people and arranging all infrastructures, the banners and all food and the stay for you people. I would also like to thank my staff from this auditorium, AV unit and hostel staff, those who are staying here for helping this training program conducting smoothly. And at last, I would like to thank all the participants. I think these are similar faces. You are coming here for most of the trainings, coming across the country and attending this training program. So please enjoy and have a lot of benefits from the speakers, those who are there. We have seen the speakers, those who are coming, they all are from very good background. Some retired judges are also coming. So please take back all the knowledge you have from this training program and utilize for your these seizures or arrest and all in your service. So enjoy these 2 days. Happy learning. Thank you very much.
Even though the session is over, but still I would like to share one thing with you. Please be very careful about the arrest and arrest procedures. Sir is also sitting there. Because as a supervisory officer, sometimes I had a very challenging time when my inspector has arrested him and was not very careful and not respecting the dignity of the person and put him in such a place where there is lots of hazardous things are there or lots of opportunity to things may happen. तो उन्होंने इनको ऐसी जगह पे रखा था, उन्होंने वहाँ का जो विंडोज़ का जो विंडो होता है ना उस पर ग्लास पेंट्स थे, वो ग्लास निकाल दिया, अपने आप को काट लिया है. तो ही वॉज प्रोफ्यूजनली ब्लीडिंग. तो ना फिर हमारा सबका होश उड़ जाता है. फिर देन हम लोग उसी में लग जाते हैं कि उनको कैसे बचाना है करके. सो असली प्रोसेस मतलब उन्होंने जो क्राइम कमिट किया है जो वो तो बिकम सेकेंडरी, हाउ टू रेस्क्यू हिज लाइफ बिकम द फर्स्ट थिंग. सो ऐसे कभी गलतियाँ मत करना, क्योंकि अरेस्ट का जो प्रोसीजर्स है, ह्यूमन राइट्स एंगल, एवरीथिंग को बहुत अच्छे से ध्यान में रखते हुए यू शुड बी डूइंग इट. ओके, थैंक यू वेरी मच.
So thank you so much, sir. Thank you so much, Dr. Rajesh Kumar, sir, for extending all kind support and providing the state-of-art facility. Now all the officers are requested to kindly join for a group photograph near the entrance, followed by a tea, and assemble at 11 a.m. Justice Indrajit Singh, sir, with us. So please be back at 11 a.m. Guard Act, Mental Health Act 1987, regular civil suits, regular appeal, miscellaneous appeals, matter under the arbitration at 1996, and execution matters. Sir also had the expertise for the criminal jurisdictions, for criminal trial cases, general session cases, and special jurisdiction for the Official Secretariat Act, SC/ST Act, MCOA, then criminal appeals, criminal revisions, session trial cases under the IPC, and pilot projects under the monitoring of the Honorable Supreme Court, India, and Honorable High Court of Delhi. CBI as a special judge for the PC Act, and also sir has acted as a resource person for the various Delhi Judicial Academy, Dwarka, Delhi, as well as for the various district court, district legal service authorities, and the various topic from time to time on the civil law and on the criminal law, including how to conduct the preliminary inquiry, disciplinary inquiry under the CCS rules and CCS conduct rules. Please welcome Justice Inderjeet Singh.
Namaskar, good morning to all of you. And a very important topic has been given today for discussion and sharing experience with you. But first of all, it is stated that I am an expert, but I am actually student, and we learn from each other every day. So in this field of law, one cannot acclaim to be an expert. With this spirit, the theme of discussion today, arrest, investigation, seizure by the police under the new act, BNSS, interplay with our main topic of the Drugs and Cosmetic Act 1940. Besides, the law laid down in Union of India versus Ashok Kumar will be the theme of discussion today. You see, you have been expert in your field, and like I have been dealing with the law, sometimes two different fields come together and it gives opportunity to share the experience. This is the first occasion that I am interacting and discussing this topic at this platform. Earlier, I always have occasion to discuss the topics at Delhi Judicial Academy and some other academies in India. You see, in the Drugs and Cosmetic Act 1948, the expression CRPC, Criminal Procedure Code, or IPC is appearing. And we also know that BNSS 2023, BNS 2023, and Bharatiya Sakshi Adhiniyam 2023 has replaced CRPC, Indian Penal Code, as well as Indian Evidence Act. Now a situation, since you are dealing with this act of 1940, now a situation before you is, this act is still containing provision and expression IPC or CRPC or some sections of CRPC or IPC. How you will reconcile it? Anyone has an idea? I don't think I am testing your knowledge. This is a discussion. The more participants you will be there, I think it will be easy for me to communicate and makes the thing clear how the law takes its shapes and how it is implemented and how actually you people enforce it. तो कैसे पता चलेगा कि उसमें CRPC लिखा हुआ है, अब ये BNSS आ गया है, तो हम आप उसको CRPC पढ़ेंगे या BNSS पढ़ेंगे, या जहाँ IPC है वहाँ आप BNS पढ़ेंगे, कैसे करेंगे? BNSS. Same logic of common sense is in the law itself. There is a General Clauses Act. Its section 7 and 8 is there. What section 8 says? If there was some previous act, but subsequently it is repealed and new enactment is made, and in that enactment similar provisions are there. Consequently, irrespective of the fact that earlier code is mentioned in the previous act, but new repealed and re-enacted law will be read therein. यानी इसे सिंपल शब्दों में कहें, हिंदी में कोई दिक्कत तो नहीं? मैं थोड़ा कोशिश करूंगा दोनों शब्दों में बोलूंगा ताकि और ज़्यादा स्पष्ट हो जाएगा. यानी 1940 के एक्ट में सीआरपीसी लिखा हुआ है. अब सेक्शन 8 जनरल क्लॉजेज एक्ट के अनुसार हम बीएनएसएस पढ़ेंगे. एक्ट 1940 में आईपीसी लिखा हुआ है, लेकिन सेक्शन 8 जनरल क्लॉजेज एक्ट की वजह से हम उसे बीएनएस पढ़ेंगे. अब मैं कुछ लाइव एग्जांपल आपको देता हूँ. आपके जो ये एक्ट है 1940 का, इसमें एक सेक्शन है पब्लिक, जो इंस्पेक्टर है वो पब्लिक सर्वेंट है. सेक्शन 22 डिफाइंस दैट देयर इज ए section 21 is the inspector, section 22 is due function, 23 is their powers of the inspector. All these things have been defined. There is a section 2U of CRPC. It is mentioned in section 26 AD. Now in the new CRPC, sorry, I'm correcting myself, it is section 21(4), which mentions that inspector is a public servant in terms of section 21 of IPC. In BNSS, section 228 is there. So in place of section 21 IPC, we will read 228 of BNS. So in this way, similar provision are there in the BNSS. For example, in section 22(4, it mentions section 94 with regard to seizure and searches. But because this code has been repealed and in its place BNSS is there, it mentions section 97. So we will read section 97 in place of 94 of CRPC. So what I want to emphasize, despite the repealed provisions are there and all expressions of CRPC and IPC are mentioned in the Act 1940, but by virtue of section 8 of the General Clauses Act, we have to read it BNSS as well as BNS. For the purpose of CRPC, it will be BNSS. For the purposes of IPC, it will be read BNS. I think this general idea will make you clear that we have to update ourselves, that the provision contained in Act 1940 are compatible with the new acts. So with this, a particular confusion shall not perpetuate in place. We shall go to the CRPC provision, we shall go to the provisions of BNSS as well as BNS. Now second is with regard to the scheme of CRPC. I am intentionally referring CRPC and correspondingly BNSS is there. There are section 4 and 5 in CRPC, and in the new act or code BNSS, correspondingly section 4 and 5 are there. They are replica of CRPC with regard to section 4 and 5. Section 4 says all the offenses under IPC, that is BNS, will be investigated, inquired and tried as per the CRPC or BNSS. Procedure how to conduct investigation, how to make arrest, how to seize the articles or thing, how to make search, how the police will investigate the matter, and finally how it will be dealt. The second part of section 2 says, in case there is a special law like this 1940 Act is there, in case there is a special law and it does not specify any provision with regard to procedure, again BNSS will be applicable. यानी अगर IPC के लिए तो ये BNSS स्पष्ट करता है कि सभी जो IPC के अंदर या BNS के अंदर अपराध हैं उसके बारे जो भी प्रक्रिया अपनाई जाएगी वो तो CRPC या BNSS के अनुसार अपनाई जाएगी. और अगर कोई स्पेशल लॉ है और स्पेशल लॉ में कोई प्रोसीजर नहीं दिया गया तब भी CRPC या BNSS लागू होगा. अब तीसरा प्रश्न है कि अगर स्पेशल प्रोविज़न दिया है तब क्या किया जाए. तो सेक्शन 4 का पार्ट 2 ये कहता है कि जो स्पेशल प्रोसीजर दिया है हम उसे फॉलो करेंगे, ना कि CRPC फॉलो करेंगे. अगर पूरा प्रोसीजर दिया है तो पूरा फॉलो करेंगे या जिस एक्सटेंट तक स्पेसिफिक या लोकल लॉ में लिखा है वो फॉलो करेंगे और बाकी CRPC करेंगे. आई रिपीट इट. द मैंडेट ऑफ सेक्शन 4 सब क्लास 2 इज दैट all offenses other than IPC or BNS will be inquired, investigated and tried as per the procedure laid down in BNSS or CRPC. But in case there is specific provision in the local or special law, to that extent that procedure will be followed. Similarly, correspondingly section 5 is there. If some power is given to some officers or some jurisdiction is vested to the court, that will also be dealt accordingly, either by general law of CRPC, that is BNSS, or as per specific law. So this is with regard to applicability of procedural law. Now I conclude on this point. Section 4 and 5 are to be read like this. In case the offences are under IPC or BNS, the procedure prescribed in CRPC or BNS is to be followed. In case the investigation or trial is to be done in respect of a special law and it does not specify any specific provision, even then provision of BNSS or CRPC will be applicable. However, in case there is some complete procedure prescribed in the specific law or local law, or to some extent it is prescribed, in that extent that specific provision will be applicable, and for rest of the things provision of CRPC, that is BNSS, will apply. Now in developing this scheme of CRPC or BNSS, there is a schedule appended at the end of BNSS. This tool classifies the offences under two parts. The first is with regard to BNS, that is IPC earlier. They have few columns. It mentions the operating part of the section, then whether it is a cognizable or non-cognizable and what punishment is there, whether it is bailable or non-bailable, and where it will be tried, either in the court of judicial magistrate or in the court of session. This is with regard to IPC, that is BNS. The second part of this schedule is for other classes of offences against other law, that is other than IPC or BNS. It has three rows, first, second and third. The bottom one also prescribes when the offense is punishable less than 3 years, then it will be non-cognizable and it will be tried by a magistrate and it will be a bailable. When the offenses are 3 years up to 7 years, then it will be cognizable, non-bailable and triable by magistrate. And lastly, if the punishment is more than 7 years or life imprisonment or death, in that eventuality, the offense will be cognizable, non-bailable, and it will be tried by court of session. Now, what is cognizable and what is bailable or non-bailable? In one sentence, it will be very clear. Cognizable means the matter can be investigated without authority from the magistrate or court, number one. Number two, the police officer or officer has a authority to arrest the person without seeking warrant from the court. This is known as cognizable. In case of non-cognizable offences, the concerned officer has to seek permission of the court or warrant of arrest, as well as for permission for investigating the matter. So far, bailable or non-bailable is concerned, in cases of petty offences, which are described as bailable in the schedule, the accused has a right to seek bail. He shall request the station house officer or concerned officer or the court that he has a right to have a bail, then his bail is granted. But so far non-bailable offences are concerned, there is no right of bail and court has a discretion to allow it or not. So far trial court is concerned, that is magistrate or session judge, ultimately where the case is to be tried and ultimately final verdict is to be given, that is maybe judicial magistrate or session court. So this is the schedule appended with the BNSS or we may say CRPC. Now this gives you a broad idea. Similarly in our this act 1940, drugs and cosmetic, you will find section 32 is there. It mentions that certain offences which is falling under section 13, 28, 28A, 20, some more sections are mentioned. They are cognizable. And second clause say that they are non-bailable. And again there is a provision of special session court that will try the cases which are described on pertaining to section 13, 20, 18, 28, 28. So these enumerations are given. Now you see, if you see the scheme of this act of 1940 as well as the general provision containing in CRPC, you will find similar expression because the legislature is same. Legislature knows which word shall be used and which word should not be wasted. So both are reconciling. But again, I am repeating, CRPC or BNSS is a general law containing general provision. This Drugs and Cosmetic Act is a special piece of legislation. It contains both substantive provision as well as procedural. So like we may say, the adjective law is CRPC or BNSS is a procedural law, but this special act contains both because the purpose of this act is to regulate manufacturing, distribution and sale of drugs and cosmetics. For regulating those provisions, it contains all these special provisions with regard to cognizance, bailable, special court, special prosecutor. So you may have a fair idea how the legislature is parallelly framing general provision as well as the special provision under the act. Again, I am coming to the first provision again. This act mentions CRPC, IPC. So wherever those expressions are appearing, either for inquiry or investigation, although word investigation is not mentioned in the Act 1948, but expression like powers of the inspector are given. If we compare those powers with search and inspection of the premises, they are replica or approximately replica of what the police officer has been given the power. So nomenclature is power of the inspector. But in CRPC or BNSS, expression given is of investigation or sometime inquiry word is mentioned. So all they are proceeding parallelly, but still it is a special piece of legislation. You have to follow the special piece of legislation. And where some provisions are mentioned, then those will be borrowed from the CRPC. So this is the general idea with regard to the general provisions of investigation, trial given in the adjudicative or procedural law of BNSS, as well as the provision containing in the Act 1940 with regard to regulations, enforcement of the provisions and carrying the functions to say not investigation but a like investigation. Now with this idea, now I am again coming to the provisions of CRPC because the today theme is arrest, investigation and search, etc. In CRPC or BNSS, there are two types of cases generally deals with, which are simply known as police case or complaint cases. I repeat, police cases or complaint cases. Again, police cases may be divided into two parts. One is cognizable, another is a non-cognizable. In cognizable offenses, I repeat, in which the police officer may investigate the matter without any authority from the court, but in case of non-bailable offenses, he has to seek the authority and permission from the Ilaka magistrate. Now, once a matter is reported to the police falling under the category of cognizable offenses, what procedure the police is following? Why I am making this detail? Because it will help you to understand what the inspector has a function, what duties he has, and what he has to perform. Then he will be able to understand those specific power given, how it is reconciling with the provision given in CRPC or BNSS. So in cognizable cases, when a matter is reported to the police registered an FIR. The moment FIR is registered, the police has authority to leave the police station for investigation. Now, as per the sequence of sections given in CRPC or BNSS, they are identical. The police officer may proceed to the spot. He may gather material evidence or articles available at the spot. He may record the statement of witnesses, and in special eventualities, the witness may be produced before the Ilaka magistrate for recording statement. This is known as statement before the magistrate. He may get recorded confession from the court also. He has power to arrest the accused also. And after arrest, an investigation is completed. Then charge sheet is filed. And charge sheet is filed before the magistrate. In case it is trial by magistrate, the magistrate will follow the procedure as per trial by magistrate. In case it is not trial by the magistrate, then he will commit the case to the session. So this is the trend being followed in the cognizable cases. Now in this investigation, I referred that police has power to arrest. Police has also power to make search and inspect the premises also. Now I just elaborate, when a person is arrested, what kind of duties a police officer has and what right an accused person has. So far arrest is concerned, the police cannot go and arrest anyone. Section are there which prescribe when police officer may arrest, like when there is appearing an offense is committed by him. If he is a proclaimed offender, that is earlier case was registered and he was avoiding the appearance, he may be arrested. When there is a credible information that offense has been committed by him, or when there is a information that this person is trying to leave the country and there are concrete information that he may avoid the arrest. So this kind of instances are mentioned in CRPC or BNSS when the police officer may arrest. Now secondly, how the arrest is made, this is also mentioned in CRPC. The arrest is made by physically touching the person, but in case it is a woman, this is a woman, then he cannot touch, there should be a lady officer, or orally it will be narrated that you are under arrest, the person is under arrest. So in this way, arrest is carried. After arresting the person, he shall be informed the reason for arrest, and his relative or friend will also be informed that this person is being arrested. He should be medically examined in the hospital so that appropriate information may be recorded in the medical examination about his physical status, whether he was having an injury or not. Then within 24 hours from the arrest, he will be produced before the magistrate. So this kind of information is given, and arrest memo should also be recorded which in arrest memo generally there are Punjab police rules applicable. It has been adopted in the Delhi, and arrest memo is prescribed. Generally that format is followed. In that arrest memo, everything is mentioned. What is the name of accused arrested, his age, parentage, the place where he was arrested, the timing of arrest, the person whom he was informed about his arrest, signature of accused person, signature of the person informed. All these information are to be given in the arrest memo. So what happened, whenever this document will go before the court may create a scene ki what actually happened, so that it may be visualized what things were happening now, which is revealing from the arrest memo. So in this way, arrest is made. Secondly is search and seizure. There are also specific provision when search can be carried. Generally, when a premises is to be searched, search warrant are taken from the court. And what precautions should be taken? For example, if a premises is to be inspected, where some document or forged documents are there, articles are concealed related with the crime, search warrant may be taken, but police has exceptional power when it appears and police officer believe that time may be taken in obtaining the search warrant and there will be delay and articles may be either disposed of or may be removed. In that situation, the police officer has to write special reason and he may approach himself or he may depute some special officer to conduct the search in the premises. Sometime it happens when search is going to be made, the entry is not allowed or some woman is there in the house. In that situation, police officer has also power to break open the door and make. These are when arrests are to be made and some situation appear before the police officer, he has to take care of the things. There was a judgment D.K. Basu versus State of Bihar. You may also note down it. In the present BNSS, all these observations made in that judgment have been incorporated in BNSS also. So the moment you have a knowledge and factors which are to be kept in mind while making an arrest or while making a search, it will definitely help. These situations may come before and how to deal with it. So this is with regard to cognizable cases. Now I am coming to the second, non-cognizable offences. In case of non-cognizable offences, whenever any person goes to the police station, he has to, the police officer cannot register the FIR in non-cognizable cases, nor it can investigate the scene. Then what police will do? There is a special form. You might have heard NCR. जब किसी का कोई पर्स वर्स गिर जाता है, ड्राइविंग लाइसेंस चोरी हो जाता है या गिर जाता है कहीं, तो हम एक NCR लिखवाते हैं, उसे नॉन कॉग्निजेबल रिपोर्ट कहते हैं. So NCR is prepared and police direct the complainant to go to the Ilaka magistrate, and then Ilaka magistrate gives the authority, only then police officer can investigate. And in case direction is given and investigation is carried, then ultimately the report is to be filed. This report is known as Kalandra in Delhi. It is a Urdu word, means it is a complaint, it is not a police report. So it will be treated as a complaint case. So it is generally referred Kalandra. In somewhere if you heard the word Kalandra, it means complaint case. So this is with regard to non-cognizable cases. Now second procedure prescribed in BNSS is of complaint cases. मैं जो कह रहा हूँ थोड़ा सा क्लियर कर पा रहा हूँ, अगर किसी को कहीं क्लैरिटी ना हो या मुझे पूछ लेना, मैं दोबारा दोहरा दूंगा, नहीं तो मैं जो मेहनत करके आया हूँ, कोशिश कर रहा हूँ, वो मेरा पर्पस सर्व नहीं होगा. मैंने सिर्फ यहाँ आके बोल के नहीं जाना. अगर मेरे आने का उद्देश्य है कि कुछ अगर इन्फॉर्मेशन या मैं जो अनुभव है आपसे शेयर कर पाऊँ और आपके काम आए, मेरा ये उद्देश्य है. तो अगर कहीं पे भी कोई हो तो आप मुझे दोबारा कहेंगे, मैं ज़रूर कह दूँगा. Now again I am coming to BNSS, that is CRPC. The second category of cases being dealt under BNSS is of complaint cases. Again, complaint cases may be of two types. The complaint cases which is triable by the magistrate, and complaint cases which is tried by court of session. This will also be relevant and material from the point of view of this Act of 1940, as well as it was also discussed in Union of India versus Ashok Kumar. So please listen it. It will be very beneficial to you. One thing I also share you. हमारे पास ना जब अपील्स आती हैं, जैसे हम डील करते हैं, हाई कोर्ट में भी अपील जाती हैं, सुप्रीम कोर्ट में भी अपील जाती हैं. होता क्या है, हमारे लोगों से भी भूल चूक होती है. हम ऐसा नहीं कि परफेक्ट हैं. जैसे मैंने कहा विद्यार्थी हैं, 30-40% जो लिटिगेशन है ना वो प्रोसीजर पे है. कैसे? जैसे हमने भी कहा अरेस्ट मीमो बनाई है, आपने उसमें अरेस्ट की डेट नहीं लिखी. जैसे फर्स्ट सेशन में भी बात हो रही थी, उसमें टाइम नहीं लिखा तो एक कंट्रोवर्सी हो जाएगी. ऑफिसर अपनी जगह बड़ा बोनाफाइड है, उसने सब प्रोसीजर फॉलो किया है, जाने अनजाने वो डेट और टाइम नहीं है, लेकिन देखने वाले को क्या लगेगा, प्रोसीजर फॉलो नहीं किया. आधे 30% जो हमारे सामने अपील रिवीजन आती हैं वो प्रोसीजर की लैप्स होती हैं. और ये जो कंप्लेंट केसेस है इसमें बहुत मतभेद हैं. कभी कभी तो उसे समझने के लिए कई वर्ष लग जाते हैं. और मैं देखता हूँ कि मैं आज कोशिश करूँगा इसे बहुत सरल ढंग से, कि अगर आपकी पकड़ में आ जाएगा तो ये एक्ट का समझ लो, आपको जो ग्रिप आ जाएगी, इसकी जो रीढ़ की हड्डी है ना, ये उसको हमने पकड़ना है. इट्स बैकबोन ऑफ दिस डिस्कशन. Now, again I am beginning it. The second aspect to be deal in the BNSS or CRPC is complaint cases. Complaint cases are of two types, which are triable by magistrate, judicial magistrate, or other triable by court of session. In our Act 1940, it is a court of special judge. Special judge is also a session judge. But legislature, in order to make it specific as compared to general procedural law CRPC or BNSS, this word or adjective special is introduced. In corruption, Prevention of Corruption Act, you will find special judge. In Makoka, you will find word special judge. Many other acts are there. NIA, special judge. So you may come across, even in the newspaper, special judge word is mentioned. It means when it is so mentioned, the legislature is dealing with the specific act. Because in the scheme of CRPC or BNSS, the court prescribed are High Court of the State, Session Judge, Judicial Magistrate Class 1, Judicial Magistrate Class 2. So there are two types of complaint. The complaints triable by Judicial Magistrate, the complaint triable by Session Court. In case of complaint triable by Magistrate, again there are two types of category. The complaint filed by public servants, complaint filed by private persons. In case the complaint is filed by private persons, the court of judicial magistrate has to record the statement of complainant as well as witnesses. And before proceeding further, notice will also be, as per new act, notice is to be given to the respondent, that is, who is going to be an accused. In the CRPC, there was no provision of notice before summoning the respondent as accused, but in the new BNSS, there is a provision, notice shall be given to be heard before proceeding further. This is one instance. In case material is found, then accused will be summoned and procedure is there how the trial will be conducted with regard to that kind of complaint. Another kind of complaint is when the complainant is a public servant. When a complaint is by a public servant, then court need not to examine the complainant and witnesses. on the basis of the contents of complaint and the documents filed, the court will consider it, take the cognizance and proceed further. That is, the accused will be summoned and case will be put to the trial. This is one component of complaint cases. Another type of complaint is when it is triable by court of session. When the complaint is triable by court of session, it is immaterial whether the complaint is by a private person or by a public servant. In both the situation, magistrate has to record the statement of complainant and witnesses. Then it will be determined whether next course shall be adopted or not. I am able to distinguish both the things. Now here, one thing is more important. When the complaint is filed, which is triable by magistrate, the magistrate has power to seek assistance of the police. For example, some particular aspect is to be verified, or some particular document is to be collected, or some kind of inquiry is to be got done. In first category of complaint, the magistrate may take assistance of the police, and whatever report will be filed by the magistrate, it will not be a whatever report will be filed by the police, it will not be a police report. It is just gathering of that specific information, document or component of evidence. But when it is triable by a court of session, magistrate has no power to give any such direction seeking assistance of the police. Am I clear? Now, accused is summoned. In case it is triable by magistrate, then copies will be provided and further trial by magistrate will be proceeded with. But in case the case is triable by court of session, then judicial magistrate will commit the case to court of session. So this is the procedure being followed so far CRPC is concerned. This is a general procedure. Now I am coming to the Act of 1940. And here some reference is required to be made in Union of India versus Ashok, in which situation had arisen that an online complaint, have you read that judgment, or someone have read the judgment? Just brief facts will be given by me. A complaint was filed on online and FIR was, some premises was inspected. That shop was there. He was asked to show the papers of medicine purchased, but the shop occupant could not produce any document and said he has no record with regard to purchase of medicine. Then inspector lodged the report with the police station and FIR was registered. The aggrieved person, that is opposite party shopkeeper, challenged it in writ petition before the High Court, and that was quashed, and certain reasons were given that Section 32 of the Act 1940 was not observed. Thereafter, matter went before Hon'ble Supreme Court of India. Union of India has preferred this writ petition. And certain provisions of CRPC, provisions of this Act 1940 were discussed. In addition, the Hon'ble Supreme Court take the aid of various other acts, and specifically 5 acts like FEMA, Customs Act, Railway Act, some more acts were taken into consideration while discussing with regard to special provisions containing in this act. As I said in the beginning, it is a special piece of legislation. It contains both adjunctive law as well as substantive law, and the purpose is also mentioned in the preamble to regulate about the manufacturing, distribution, sale of cosmetics and drugs. The legislature has divided this act into different parts. Part 3 with regard to imports, Part 4 with regard to manufacturing, etc. Part 4 is there, with regard to Siddha, Ayurveda, etc. And then miscellaneous, another chapter is there. And in this judgment of Union of India versus Ashok Kumar, chapter 4 was under consideration with regard to functions and power of the inspector. If we see the power of the inspector, throughout, either in the Act or in the recently framed rules, cosmetic rules 2023, or earlier drugs and cosmetic rule 1945, the expression investigation is nowhere found. But certainly provisions of inspection, search of person, entry into the house and then search, asking the person to produce documents, register, etc., and their seizure so required for a particular period, and appropriate order by the inspector. All these things are there. By keeping both the provisions side by side, we may conclude one thing, that inspector has certain powers like a police officer has power as an investigator. So, when the inspector acts and conducts the functions within the parameter of this specific piece of legislation, those power also includes, as I said, search and seizure, etc. are there. But these specific provisions are to be followed while carrying inspection, search within the parameter, being an expert or being specialized, having experience in the line of medicine and cosmetics. Vis-a-vis, some provision has been introduced with regard to CRPC, now I may say BNSS, while making and performing duties under the Special Act of 1940. In this regard, when this case of Union of India, Ashok, was being dealt with, the question arises that section 32 talks about cognizable offences. It also talks about non-bailable offences. It also talks about special code to deal with certain offences under section 13, 28, etc. But inspector has not been given power to arrest. And simultaneously, provisions of CRPC are also not applicable, because police performs its function of arrest and investigation under BNSS, which regulate when the FIR is registered there. And it was discussed that the inspector who got the FIR registered, in fact, assigned the investigation to the police. But the police is not competent to carry the investigation with regard to offences committed under Part 4 of the Act. So ultimately, question had arisen, if a bona fide purchaser of medicine or someone comes in the office of inspector and gives a report, he may carry the investigation because he has a power, he may do needful. But in case that person goes to the police station and duty officer sitting there innocently register the FIR, or it comes to the cognizance of station house officer that a report is received with regard to this Act of 1940, then what to be done? In this Union of India versus Ashok, it was held, it is the duty of police officer to immediately and promptly return that complaint to the concerned Department of Drugs and Cosmetic, then the inspector will initiate the process. Now there are two parts. In part 4, 4 persons or authorities may initiate the action, and when it is part 4A, then only inspector is there. In part 4A, inspector is there, aggrieved person may initiate the process, gazetted officer authorized by a specific order may initiate or some registered consumer association may proceed the process. So this is with regard to part 4. So for section part 4A is concerned, 33M is there. Only inspector has the authority, subject to he has been given authority to lodge the complaint. So in that case, it was determined that inspector is competent to carry the functions and duties assigned under the Act, and he may proceed with the matter. And if mistakenly or otherwise case comes before the police duty and obligation is imposed that it will be sent back promptly to the concerned department to do needful. This is one aspect. अब second question arises, the Act and rules are silent with regard to power of arrest. Whether he can arrest or not, this is the another question arisen before Honorable Supreme Court, and it was beautifully and answered in detail while discussing section 22. Just I may see because I am not recollecting it. Anyone? Section 21D. 22D, powers of the inspector. This provision was harmoniously read with the other provision. Once a section 32 says that it is a cognizable offense. Cognizable offense means the person or accused may be arrested without warrant from the magistrate, but police has no role at all. But Act is also silent. That arrest cannot be made by there is no specific provision, neither it is bar nor it allows. But this 22D was interpreted keeping in view the scheme of Act that in order to perform that functions, the inspector may arrest it. But a rider was put that norms laid down in D.K. Basu versus State of Bihar case will be followed. Those majority of the norms are in CRPC. Like I said, when arrest is made, then what to do? He will be informed about the arrest. Some relative or friend will be informed. Arrest memo will be drawn. He will be medically examined. And in case some detention is kept, then again he will be medically examined. So all these norms are to be followed. And ultimately he has to be produced before the Ilaka magistrate. So this was mentioned in that judgment that inspector has a power to arrest, but as in the first opening session, all precautions are to be made. क्या होता है कि हम सब मानव हैं, भावनाएं होती हैं, कभी कभी आदमी को लगता है ये देखो ये बहुत गलत कर रहा है, तो आवेश में आ जाता है. उसकी नीयत बुरी नहीं होती, लेकिन कई बार आवेश में भूल चूक हो जाती है. लेकिन ये विधान और जो निर्णय है वो कहता है कि इसको भी थोड़ा सा कंट्रोल कर लिया जाए तो बहुत बेहतर रहता है, क्योंकि नीयत तो साफ है, लेकिन भावना के कई बार कोई चीज़ ना बिगड़े तो ज़्यादा बेहतर रहता है. इसी प्रकार इन द सेम वे search and seizure is also there. In the old Act, there was no provision of audio-video recording, but in the latest BNSS, Section 105 has been introduced that audio-video may be recorded. And I think in the morning session, it was also pointed out there is a special session to deal with it, and it will be taken care of. So these are the provisions with regard to how general law operates, how specific law is to be implemented, and how to reconcile the provision of specific law along with the general procedure given in CRPC, and to look into the enforcement and implementation of the provisions of law. So with this, I conclude my presentation, and in case there is some question, I will try my best to answer it.
Thank you for the presentation, sir. Sir, I have one question, sir.
Yes.
Sir, what is the difference between the preamble and statement of objects and reasons? And where can we find this?
When the bill is introduced in the parliament or legislative assembly, wherever they have a certain objective why this law is being brought. And preamble is a concise statement of those objectives to be achieved. So it is a expression of enactment. जैसे हम घर का पता होता है ना, घर का पता होता है तो एड्रेस लिखा रहता है, उस पर पहुंचना बड़ा आसान हो जाता है. So it is a like mind of the legislature. What objectives and what aims were kept in mind to frame this act? Like in this present act, earlier it was only confining to drugs, but later on cosmetic word was introduced to regulate manufacturing, distribution and sale of drugs and cosmetic. Now if you see, please have a seat. Now you see the chapter wise. There is a provision with regard to import, with regard to manufacturing, with regard to other medicines, and adulterated drugs are there, misbranded drugs are there. You see, and connect them with the preamble. So ultimately they are to be regulated. So in briefly, it is a address of the contents or operating part of the act.
In case of any complaint or any prosecution, which one will prevail, sir? The preamble will prevail or the provisions under sections of the act will prevail?
In our interpretation of provisions of the statute, there are certain judges developed the law. Like, one is a literal rule, second is a golden rule, third is a mischief rule. In case of literal rule, we have to interpret the law as it is. But sometimes we are not able to see it. Then we see what is the golden rule, how it should be reconciled with a particular act. And lastly, if something is to be there, we are not gathering, then we see the objective of the law. But this interpretation is to be given not by the district judiciary, either by the High Court or by the Honorable Supreme Court of India.
One more question, sir. So sometimes after the act is introduced, there will be many amendments happening to it. So when all the amendments are happening, again the preamble will be changed according to that, or the initial preamble only will remain?
Generally, amendments are carried with certain purposes. Sometime it may happen, there are some omissions. Like in Union of India and Ashok Kumar judgement, you will see while discussing with the Railway Act and FEMA and Custom Act, there are certain requests by the Honorable Supreme Court to the legislature to please look into it and remove the dilemma by whatever legislation are there. There are different circumstances when amendments are to be carried. But generally, no such amendments may be carried which may change the basic structure of the case. So it hardly happens.
Thank you, sir.
सर अर्लियर सीआरपीसी में जो प्रोविज़न था कि कोई भी पब्लिक सर्वेंट अगर कंप्लेंट फाइल करता है तो कोर्ट डायरेक्टली कॉग्निजेंस ले लेती थी. अभी प्री कॉग्निजेंस कॉन्सेप्ट आ गया है कि नोटिस देंगे एक्यूज़ को और एक्यूज़ जब तक आएगा. तो सर इसका एडवांटेज क्या हुआ बीएनएसएस में? बिकॉज ये कहते हैं कि बीएनएस इसलिए आया कि ट्रायल जो है वो फास्ट ट्रैक पे चले. बट ये प्री कॉग्निजेंस की वजह से हमें ये लगता है कि हमारा जो केस जो पहले हम एक हीयरिंग में 2 हीयरिंग में कॉग्निजेंस करवा देते थे, अभी नोटिस पे एक्यूज आएगा नहीं आएगा, तो इसका बेनिफिट क्या हुआ और इसका पर्पज क्या है सर, ये समझना चाह रहा था सर.
प्लीज हैव ए सीट.
यस सर, थैंक यू सर.
इसमें बहुत सारे मुद्दे इन्वॉल्व हैं. साधारणतः तो यही है कि जो नेचुरल प्रिंसिपल ऑफ जस्टिस है कि आगे बढ़ने से पहले सुनवाई भी की जाए. जब हम सब कई जगह डेटा इकट्ठा करते हैं तो कई बार ऐसा भी होता है कि लोग कंप्लेंट फाइल कर देते हैं, ठीक है, उसका दुरुपयोग किया जाता है. तो लेजिस्लेचर के सामने कुछ डेटा ऐसे आए होंगे जिसकी वजह से ये बनाया. अगर आप प्रैक्टिकली देखें, अगर उसे नोटिस भेज भी देते हैं तो कुछ तो आगे कहेंगे सर मुझे क्यों बुला लिया, मैंने क्या कहना, आप प्रोसीड करो. दीज इंस्टांसेस आर हैपनिंग प्रैक्टिकली. और कहाँ भी जहाँ डॉक्यूमेंट्री एविडेंस होता है कहते सर ये झूठा केस है, मेरे पास तो ये डॉक्यूमेंट है. सो इट वेरीज फ्रॉम केस टू केस. देयर इज नो स्ट्रेट जैकेट फार्मूला. वी मे से by virtue of this provision, what is the purpose going to be? The principle of natural justice has been invoked first time. Otherwise, earlier, not only in 1973 CRPC, even in 1890 CRPC, there was no such provision. नहीं, मौका दे दिया, उसकी इच्छा नहीं आई, कोर्ट प्रोसीड करेगी. उसको कोई अभी तो वो एक्यूज नहीं बनाया, रिस्पोंडेंट है. आई इंटेंशनली यूजिंग दिस वर्ड. वो नहीं आएगा तो कोर्ट प्रोसीड करेगी. उसको मौका दे दिया, उसके घर तो जाएंगे नहीं. हमने नोटिस देना था, लॉ की रिक्वायरमेंट थी, उसे सर्विस करवा दी. अब उसका हेडेक है, वो आए ना आए, नहीं आएगा तो प्रोसीड करेंगे. जैसे सिविल केसेस में क्या होता है एक पार्टी नहीं आती तो नेक्स्ट पार्टी प्रोसीड करते हैं। इसी तरीके सर्विस हो गया, उसकी मर्जी या नहीं आएगी तो प्रोसीड करेंगे। At which stage? At which stage? At which stage? नहीं यार, तो वही बात है, सर्विस हो गया, पर्पस है एफिक्सेशन से करवाया जा सकता है। अब तो सर्विस के बड़े मोड हैं, तो किसी भी मोड से सर्विस हो जाए, इट इज सफिशिएंट सर्विस। इवन व्हेन कंप्लेंट परटेन्स टू BNS प्रोविजंस, इवन द सर्विसेज ऑफ पुलिस में भी टेकन, देयर इज अ प्रोसेस सर्विंग एजेंसी इन दिल्ली में, कहते हैं 5B की सर्विस होती है, यानी चैप्टर 5 पंजाब पुलिस रूल्स के अंदर सर्विस का एक अलग से डिपार्टमेंट बना हुआ है, उसे 5B की सर्विस कहते हैं, रोमन 5। तो देयर इज अ डिपार्टमेंट, वी मे आल्सो अवेल द सर्विसेज। उसको तो मैं कोई कमेंट नहीं कर सकता उसके बारे में, डिपेंड्स पर्सन टू पर्सन।
Sir, like earlier we used to file the FIR for the arrest of a person accused. Now after Ashok Kumar judgment, now we have to arrest the person, and like how we can take the police assistance in that case, like how to keep the person, like in our office we don't have the the place to keep the accused, and like in police we have malkhana. So we are seizing the material and we are keeping in our cupboards. We frequently get transfer again and again after a certain interval time, because there is no malkhana type of practice in our office. So what about the custody of those material? What are the after a certain 5 or 10 year court may ask to exhibit the material in front of the court. So we have such issues. Then how to take the police assistance? How to keep our material in the police malkhana? How to facilitate our activities for this, because we don't have the police infrastructure in our department.
There are twin questions. I reply one by one. First of all, with regard to arrest, in CRPC, that is general law, a private person may also arrest, but it is the obligation to hand over the accused to the police. Then police will re-arrest him, and appropriate seizure, arrest memo will be drawn. Then process will start. He will be produced before the magistrate. This is one aspect. So far, arrest by inspector is concerned, same provision will apply. That is, he can't take the assistance of police, but he has to be produced in the court as per the norms. Because inspector himself is an authority as per law. So he has to, उसको लाने की पहली जगह तैयार कर लो, दफ्तर में बिठाना कहाँ। So far case property is concerned, you know, there is a Punjab Judicial Malkhana Act from the Britishers' time. It was extended to Delhi, but till there is no judicial malkhana. So all articles which are seized by the police, or some even in accident cases also, when the vehicle is taken into possession, all are kept in the police malkhana. It is a temporary arrangement, and by way of notification, those places of police station have been notified for keeping the articles there. I think similar situation is with you. The department has to make arrangement so far this keeping of articles is concerned. Otherwise, where you will keep it? They are material evidence. एक बड़ा सरल शब्दों में मैं एक चित्र बनाऊंगा आपके सामने। आपने प्रारंभ से लेके अंत तक जब कंप्लेंट फाइल करनी है, बहुत इंक्वायरी की, सारे प्रावधानों का पालन किया। जब कोर्ट के सामने मुकदमा आता है ना, उसे आपने एक रिस्ट्रक्चर सीन करना है कि ऐसा हुआ था, ये मेडिसिन थी, स्पूरियस थी, या जो भी थे एलिगेशन अडल्टरेटेड थी, वो सारा का सारा सीन तैयार होना है, कोर्ट के सामने आपने करना है। अब अगर उसमें आपकी सीजर मेमो ठीक नहीं है, या आर्टिकल जो है वो स्पॉइल्ड हो गया, उसकी सील सही से मार्क नहीं हुआ, वो तो सारी आपकी मेहनत व्यर्थ चली जाएगी. इट इज़ अ मटेरियल एविडेंस. सो डिपार्टमेंट हैज़ टू लुक इनटू इट. So far judiciary is concerned, I think it is the prosecution case. Prosecution has to prove the case, and all these articles have to be kept intact so that court may take as a convincing evidence.
उसको वहाँ से रिलीज कर दिया और साथ में कुछ वार्निंग्स भी दी डिपार्टमेंट को कि इस तरह के इंसिडेंट ना हो. तो जैसे पुलिस के पास तो एफआईआर किया, केस फाइल करने से पहले उनके पास इन्वेस्टिगेशन के टाइम पे वो एफआईआर के बेसिस पे कर रहे हैं. अब हम किस सेक्शन के अंडर या किस प्रोसीजर में लाएंगे कि कंप्लेंट केस, जैसे हम सेक्शन 223 में कंप्लेंट फाइल करेंगे, वो तो फिर उसको पहले रेस्टोरेंट को एक बार करना है. तो अरेस्ट करने के बाद, जैसे हमने आज अरेस्ट किया, तो मुझे किस सेक्शंस के अंडर मैं उसे मजिस्ट्रेट के सामने प्रोड्यूस करूं? वो जो 58 वाला सेक्शंस का सीरीज है उसमें करूं जिसमें लिखा होता है कि विद इन 24 आवर्स ही हैज टू प्रोड्यूस इन द कोर्ट. उन सेक्शंस में मुझे अपनी एप्लीकेशन फाइल करनी है या ऐसे सेक्शन 32 मुझे कंप्लेंट केस फाइल करना है इनिशियल स्टेज पे ही?
अगेन यूनियन ऑफ इंडिया वर्सेस अशोक की जजमेंट लागू होगी, आप उससे बाहर जा ही नहीं सकते.
कैसे सर?
यू आर टॉकिंग अबाउट 156(3). हियर so far part 4 offences are concerned, it will be by the inspector. In case some other offences are also made out, only then magistrate can make a direction for investigation, not with regard to chapter 4 offences. For example, in BNSS there are provision of section 275, 276, 277 with regard to preparation and adulteration of drugs. It is an offence under IPC, that is BNS. The police may make investigation or the court may direct under section 156(3) with regard to those offences. But so far part 4 offences are concerned, it will be a complaint case.
नहीं सर, जब कंप्लेंट केस फाइल करेंगे तो पहले तो वो एक्यूज्ड को अरेस्ट जब हम करेंगे तो उसके टाइम पे तो बोलेंगे आप उसको अरेस्ट नहीं, क्योंकि अभी कॉग्निजेंस तो कोर्ट ने लिया नहीं है, प्री कॉग्निजेंस स्टेज पे.
This is a grey area.
तो फिर जब मैं आपको जो कोर्ट का ऑर्डर है, आई विल रीड फॉर यू.
No, this is a grey area, I am saying.
तो इसका क्या सॉल्यूशन है? क्योंकि
actually you are comparing when police investigate the case, simultaneously they arrest the accused. If I'm, but so far complaint case is concerned, cognizance is yet to be taken and accused is arrested.
तो कंप्लेंट केस कब फाइल करना है? जब हमें प्रोसिक्यूशन फाइल, जब हम फाइनल अपना इन्वेस्टिगेशन कंप्लीट करने के बाद उसको हम कंप्लेंट केस का नंबर देंगे, या इनिशियली वो ऐसे कंप्लेंट केस ही फाइल होंगे? क्योंकि केस फाइल करना और इन्वेस्टिगेशन इनिशिएट करना दो अलग अलग चीज़ें हैं. एफआईआर के बाद पुलिस केस नहीं फाइल कर रही है, पुलिस एक कंप्लेंट को, एक इन्वेस्टिगेशन को इनिशिएट कर रही है, और जब वो चैप्टर 12 में अपनी फाइनल शीट लगा रही है तब वो प्रोसिक्यूशन फाइल हुआ है. उससे पहले प्रोसिक्यूशन फाइल में, उससे पहले केवल इन्वेस्टिगेशन था. तो ऐसे ही जब वो चैप्टर 12 का जो प्रोसीजर है वो पुलिस के लिए है, और सेक्शन 220, सेक्शन 200 सीआरपीसी, 223 बीएनएसएस वो बाकी जैसे कस्टम्स हैं हमें, हमारे या सीबीएन है उन लोगों के, हमारे जैसे लोगों के लिए है. तो केस तो फाइल होगा बाद में, जब मैं अपनी इन्वेस्टिगेशन कंप्लीट कर लूँगा. तो उससे पहले जो मेरा इन्वेस्टिगेशन है, मैं एक बंदे को अरेस्ट करूँ, 2 को करूँ, 4 को करूँ, वो किन सेक्शंस में मैं उस चीज़ को न्यायालय के सामने लेके जाऊँगा?
Again I repeat, this is a grey area. It is yet to be settled. He has not made an accused, because after preliminary evidence or whatever, it will be committed to the session, then he will be summoned.
तो सर फिर तो मतलब हम अरेस्ट कर भी सकते हैं, और वो अरेस्ट जैसे हम करेंगे तो न्यायालय उसको तुरंत छोड़ देंगे पहले उसका, या सेम डे न्यायालय, क्योंकि सेम डे तो कॉग्निजेंस न्यायालय उसका लेगा नहीं
लेगा. That is what I am saying, it is a grey area. It is yet to be settled by judicial precedents.
Okay, thank you, sir.
So with this question, we are going to end up the first session of the day. May I request Dr. S. Ishwara Reddy sir join. Okay, this is the last question from Sushant. Please quickly ask your question so that we can start the next session.
हम लोग सर रेगुलेटर भी हैं, तो सम टाइम क्या होता है कि हम कंप्लेंट के बेसिस पे किसी भी प्रीमाइसेस में एंट्री करते हैं, तो एंट्री के दौरान हमें वहाँ पे मटेरियल मिलता भी है या नहीं भी मिलता है कि जिसको सीज करना हो, या ड्यूरिंग सम रूटीन इंस्पेक्शंस हम अगर रूटीन इंस्पेक्शन कर रहे हैं किसी भी प्रीमाइसेस का, तो हमें कुछ ऐसा मटेरियल मिल जाए जिसको हमें सीज करना पड़े। तो अब BNSS क्या कहता है कि आपको वीडियो रिकॉर्डिंग करना है या आपको विटनेस लेके आना है सीजर के दौरान। तो अगर हम रूटीन इंस्पेक्शन ऑलरेडी कर रहे हैं, 4-5 घंटे से उस प्रीमाइसेस में है, जो हम अपना रूटीन इंस्पेक्शन और चेकलिस्ट फॉलोअप कर रहे हैं, लेकिन अचानक हमें ऐसी चीज़ मिल जाती है दैट रिक्वायर्ड टू बी सीज इमीडिएटली, तो क्या हम 4-5 घंटे तक रिकॉर्डिंग करते रहे लगातार, या उसी समय रिकॉर्डिंग शुरू करें कि हमारा केस वीक ना हो जाए? तो ये सब चैलेंजेस हमारे सामने आते हैं, तो इस प्रोसीजर्स को भी थोड़ा सा अगर लाइट दे कैसे इसको डेल्ट करें।
Although there is special section, but for the purposes of this query, you see in CRPC, it was not containing any provision with regard to audio video. It is the first time introduced under section 105 of BNSS, number 1. Number 2, not only you have to carry, it is not necessary you shall carry the camera. As per 105, even it can be recorded in the mobile phone also. Secondly, it does not require that you shall record everything minutely, the incriminating evidence. But ultimately, what is to be proved in the court? The incriminating evidence. It should cover that one. If it is covered, then it will suffice.
एंड सर अगर विटनेसेस शुरू से नहीं है, उस समय अगर विटनेसेस कहीं हम इंडिपेंडेंट विटनेस कॉल करते हैं एट द टाइम ऑफ द सीजर, so it will be admissible in the court?
There are two components. If the witness is not available, it should be reflected that the concerned officer has made an attempt to secure the presence of neighbor or some independent witness. This is one component. In case it is failed, then you may proceed with the seizure. But it should be reflected in the record that best efforts or reasonable efforts were made to secure the attendance of witnesses. In case witness is available, then the seizure memo bear the signature of that witness. Not only that he just put his signature, but entire proceeding of seizure was conducted in his presence. This is the requirement.
Thank you, sir.
हाँ जी, देखो बड़ा सरल है, ये हमारी आंखें क्या हैं, मैं आपको देख रहा हूँ और मुझे आप देख रहे हो, ये वीडियो ही चल रहा है
जी जी,
अब वो हमने मशीन में डाल दिया,
Yes.
यही तो है। हम थोड़ी सी चीज़ भूल चूक भी कर लेंगे, मशीन तो वैसे की वैसी बोलेगी जैसा भी है।
तो सर उसके में 65B का सर्टिफिकेट कौन इशू करेगा? जैसे हमने जो वीडियो रिकॉर्डिंग करी है
वही करो।
तो 65B का सर्टिफिकेट
Those who will make output of that digital evidence, they have to provide the certificate. And one thing, since you are dealing with a very sensitive matter, we come across certain kind of 65B certificate. Like I recorded, this is output. Like 2 or 3 sentences are written. I went there, I was carrying mobile phone, and I prepared this video, and this output, that is hard copy, is matter thereof. It will not satisfy the requirement. Please read judgment of Guru P.N. Anwar versus State Delhi Administration. My Lord Justice Pradeep Nanjog has discussed in detail. What you have to say, this was the mobile phone. You write its model, if possible IMA number, then give the certificate. It was functioning properly when I snapped this video, and ultimately on this date this output was taken. It will suffice the requirement. Secondly, actual data is in the mobile phone. The moment, either in the binary form or whatever be, the output is in a journal way. So it is a converted form. So what legislature did, it is neither a original evidence nor a secondary evidence. It is in middle of the both. This is known as special evidence or digital evidence. So that is why this 65B certificate was prepared, because it doesn't fall in the category of original document or evidence, nor in the secondary, but in special category.
तो जो ओरिजिनल डिवाइस है इट शुड बी प्रिजर्व्ड, और क्योंकि बाकी केसेस में कोर्ट न्यायालय का जो राय कि ओरिजिनल जो डिवाइस है इसको भी प्रिजर्व रखना है आपको, ओरिजिनल जो फुटेज है। तो अब चूंकि अब उसमें BNS में इटसेल्फ लिखा हुआ है कि प्रेफरेबली बाय द मोबाइल फ़ोन, गवर्नमेंट ने जो लेजिस्लेचर ने जो एग्जीक्यूटिंग एजेंसी उस पर डाल दिया आप मोबाइल फ़ोन यूज करिए। तो मोबाइल फ़ोन को प्रिजर्व रखना भी आज की डेट में एक वो है कि
मान लो मोबाइल फ़ोन ना हो
जी,
आपने फाइल में रखा हो, तो फाइल में ओरिजिनल रखेंगे? फाइल में ओरिजिनल ही रखेंगे। इन केस दिस बेस्ट एविडेंस इज अवेलेबल, व्हाई नॉट टू प्रोड्यूस इट?
किस स्टेज पे प्रोड्यूस करना एक्चुअली?
एविडेंस की स्टेज पे
नहीं,
Evidence
जस्ट
की स्टेज
मैंने उसमें से जो अपना वीडियो था, ऑडियो विजुअल का जो वीडियो था, मैंने उसको एक्सट्रैक्ट किया, उसकी हैश वैल्यू निकाल के, और मैंने 2 या 3 पेन ड्राइव क्रिएट करी, सील करके मैंने एट द टाइम मैंने न्यायालय को बता दिया कि मैंने जो 65 के एविडेंस के साथ ही कि इस पेन ड्राइव में या हार्ड ड्राइव में ये डाटा विद दिस हैश वैल्यू ये है, ये पेन ड्राइव का सीरियल नंबर है, ये हैश वैल्यू है, और इस मोबाइल से लिए। उसके बाद तो मोबाइल का रिक्वायरमेंट क्या एविडेंस के टाइम पे होगा?
जरूरत तो नहीं है, लेकिन अगर क्रॉस एग्जामिनेशन में हो तो कोर्ट परमिट कर सकती है कि आपको पेश करना है।
पर वो एक्चुअली मोबाइल पर्सनल मोबाइल है, तो हम ये नहीं कह सकते ना
वो जो डेटा है वो पर्सनल नहीं ना रह गया। दैट डॉक्यूमेंट इज नॉट पर्सनल।
So thank you so much, sir, for your wonderful and interactive session. May I request Dr. S. Ishwara Reddy, sir, Joint Drug Controller India, to please come and present the memento to Justice Inderjeet Singh, sir, as a token of appreciation. Now we are going to start the next session of the day. We are here eminent speaker Dr. Annam Vishala madam. So she is the Joint Drugs Controller India and working as a CDSCO. Madam has a career for spanning 30 years in the regulation, more than 30 years, and by qualification madam had PhD in the pharmacy. She was selected as APPSC, Government of AP, as first women drugs inspector for the state of Andhra Pradesh in the year 1992. Madam worked at DCA AP for 17 years as drug inspectors and later promoted in 2009 as assistant director. During her stint at DCA AP, she has conducted a GMP, GLP audit of the manufacturers, detected several substandard and spurious drugs, launched various prosecutions as drug regulator. Madam also held the post of licensing authority for sale and was instrumental in conducting raids, surprise checks for ensuring the quality of the drug being marketed. Madam also has enforced various other laws such as DPCO, DMROA. She also had later selected by UPSC as Deputy Drugs Controller India and joined the National Regulatory Authority CDSCO in the year 2012. During 2012 to 2017, she has worked in the Division of Global Clinical Trial, SAE Compensation, Medicine Safety Monitoring Wing, Ethics Committee, Registration Division at CDSCO, and also reviewed the clinical trial protocol. I am also fortunate to work under the able guidance of Madam in the year 2012 when the Ethics Committee registration and the policy for the global clinical trial was under the reformation. And Madam also had having the expertise for reviewing the clinical trial protocols as well as the clinical data, safety data, PSUR, and assisted DCGI in the regulatory action under the provision of Drugs and Cosmetic Act and rules. From 2017 to 2022, she has worked for around 5 years at CDSCO Zonal Office Hyderabad and Zonal Head for the enforcement for the provisions of Drugs and Cosmetic Act, NDCT Rules 2019 and MDR 2017. She has completed WHO Rotational Fellowship Program at Geneva, Switzerland with respect to the assistant of the dossier of the API and formulations held in 2018. Madam is the first woman recipient of Best Drugs Inspector Award in the year 2002, instituted by the ADCOG, and she also holds the distinction for the recipient of the Best Women Regulatory Officer, the first ever NIHFW Award in the year 2019 for the excellence in the service of the drug regulatory officials. Since 2023, she has posted at CDSCO headquarters, New Delhi, and assisted DCGI for the division of the enforcement cell, legal cell, ethics committee registration, apart from the functioning of additional charge of CDTL Hyderabad. Please welcome Dr. Annam Vishala, Joint Drugs Control India, CDSCO.
Very good morning to all the participants. At the outset, let me congratulate Training Cell under the guidance of Dr. Ishwara Reddy, Naresh Sharma and others for envisaging this workshop. And I'm sure it is going to be of great help for you, right? So I'll be starting with the various provisions under the Drugs and Cosmetics Act, the medical device rules and the cosmetics. I'm sure you're all aware of this. So it's only a brief snapshot to bring about the differences and the various provisions that we have for between drugs versus cosmetics and medical devices. Then I would share a few of my experiences and what has changed over the past 32 years of my experience and where are we headed, right? So briefly, so when we talk of the powers and procedures for inspectors, we definitely ought to look at the DNC Act followed by the rules. The rules also has various, the Act and rules has various schedules. Circulars are issued from time to time, but within the tenets of the law. Various guidance documents have been published by CDSCO. There are several office orders, but these office orders are basically to give you guidance on technical matters. Interpretation of sections is definitely the prerogative of the honorable courts, and the guidelines, office orders and circulars are basically for assessment and to help you in the technical matters. And I'm sure since morning you have heard the chief guest as well as other speakers, they have very well said that this law is a very special act, and we use various other acts and other provisions, general provisions such as CRPC, IPC, which is now BNS, and also Evidence Act, correct? So we should be conversant with all these rules. Apart from our technical laws and technical rules, we must be conversant with the associated laws when we want to take action, particularly by way of arrest and eliciting evidence. So if you look at the basic meaning of what is power, power could be the capacity to direct or elicit influence. Do I have a mic? Caller mic? So it looks like I have to take the seat. So the power here has been defined as the capacity or ability to direct or influence the behavior of others or the course of events by restricting or changing the movement of person or material in accordance with the provisions given under the applicable law. Ultimately, it helps you to act as per the provisions of the law. This is dynamic in nature. That is, whenever a rule changes or what is ambit of the rule, then the powers vested with an inspector would also become dynamic in nature. For example, like the previous speaker said, the law was basically for drugs, and later on they added cosmetics, and now it has medical devices. Of course, medical devices were long there, but it is well defined under the rules now. Now the authority is definitely to command, or you derive the authority from the sections and the rules. Under the Act, we all know that the licensing authority is a quasi-judicial function, meaning that there are both administrative powers as well as legal powers, that is cancellation of licenses, etc. However, an inspector is the one who is vested with the powers for inspection and taking action, including prosecution. These are the various chapters under the drug rules. We are aware that the most important ones are Chapter 3 and Chapter 4, including Chapter 5. Chapter 2, yes, you should understand what are the provisions under Chapter 2 and how the DNC law is governed as a whole, because we have a technical board, we also have a drugs consultative committee, and when you are in the court and there are certain questions asked by the lawyer or even the judge as to where it is written, as to what is the role of a laboratory, etc., you should be aware of the entire sections under the Act, including the rules, because you are a technical officer. We are also aware of the definition of an inspector, particularly in respect to drugs, other than Ayurvedic, Siddha or Unani. The inspector is defined in relation to drug or cosmetic or inspector appointed by the central government or the state government under Section 21. Now, what are the powers of an inspector has been enunciated in Section 21. Simply put, you have the powers of an officer under the state or the central government based upon the notification that has been given to you. That is the Gazette notification. And the rule says that you are notified for a particular jurisdiction. Even in the state of Andhra Pradesh where I worked, our notification was for the entire state. A few of the states like Karnataka had districts as their jurisdiction, whereas in Andhra Pradesh we had the entire state, meaning that I could function or I could be transferred across the state, but still the singular Gazette notification stays. So I do not know how it works now. They have now shifted to the district as a jurisdiction or a location. That means you are notified for one jurisdiction or a location. So I think CDSCO's inspectors are notified for the entire country, and meaning that you can use this provision to investigate at any part of the country. So an inspector is also a public servant, and we should never forget this. Meaning that we are also bound by the IPC, formerly, now the BNS. So what are the powers that an inspector has? First and foremost, you are notified for a particular jurisdiction within the local limits. You are a public servant, you are bound by BNS, and you have powers to inspect a premises, to draw samples, to search a person, place, vehicle or other conveyance, examine a record, register or document, and seize, or if you have a reason to believe that it may furnish evidence of commission of the offense. or require any person to produce any record or register or other document. Exercise such other powers as may be necessary. That is 22D. So I think this was the very 22D based on which the Ashok Kumar judgment has also been given. That is, you have the powers to arrest. So once you have these powers of, record seizure or register seizure, you will have to also intimate the magistrate once you have seized these goods, records, and within 20 days of seizure and intimation to the court, you will have to return this material to the person from whom it was seized, that is particularly the records. Because the records may be of use to him, or you may obtain under section 22(1) CCA the records or extracts thereof and use that in lieu of the seized records, since you have returned these records to the other person. These are a few of the powers that you have. That is, various legal basis has been specified here, but I doubt if document examination is under 22(1)(e). I think there is a mistake over there. So let me go back to the previous slide. It talks of prosecution. To initiate prosecution in appropriate court after due investigation under section 32, you can launch prosecution. Does it require the permission of your superior authority as per the rule? Yes, no? Yes, it requires. Okay, so, pardon? Yes, you're right, very much. It is only an administrative procedure for seeking prosecution permission. Otherwise, the inspector is fully empowered to launch prosecution. To have uniformity in the way we work, we require administrative power order, but otherwise you can launch prosecution. Usually we don't file the prosecution permission issued by the licensing authority or the controlling officer of the state along with the complaint, because that was also being questioned in the courts. Though that is only an internal order for uniformity in the way we work, it was also subject to questioning. I remember this happened even in the case of CDSCO. There were comments made on the NOCs given for prosecution by the honorable courts. So whether this is required or not required, my opinion is it is not required. You may proceed to file after scrutiny by your senior officials, particularly a complaint copy. And I hope you are all aware that Andhra Pradesh has also Gazette notified their SOPs and official procedures. You can have a look at it, go through it. It is of, these were the practices that we had followed as well, but they made it into an SOP for all their officials. They have fixed the responsibility on the inspectors, also the assistant directors. And for a novice in this field, I would say that is a very good read. If you can, I think Enforcement Division is here? No. Okay. So I can share the link, or you can just download the GOMS and then read for your basic understanding. So we are also aware of the sampling procedures. That is, when we want to draw a sample, either from the marketplace or from the manufacturing site, we have to issue Form 17, Form 17A, where the price is refused. And then we proceed to divide the sample portion, seal the sample portion into either 4 portions or 3 portions, depending upon whether it is a retailer, wholesaler or manufacturer, and hand over a copy of the sealed portion of the copy of the Form 17 as well as a sealed portion and 17A as well. Meaning we are preparing these in triplicate, whereas a sample portion can be in 4 parts or 3 parts. So sealing should also be to ensure that we do not tamper. It should be tamper proof. When you seal a sample portion, it should be tamper proof. And ensure that no part of it can be replaced either by the inspector themselves or even by the person to whom the sample was issued. Therefore, sealing is a very important technique. Learn the sealing process and ensure it is tamper proof, because it could be a property to be submitted to the court. Am I correct? So it is not just the NSQ portion sample, but also it could be seized property. The question is, if I seize the property, how do I ensure that the material is tamper proof? Sometimes I would have to seize large drums, huge quantity of API. Then how do I ensure that I seal on each container? No, it is not required to seal every container closure, but ensure it is made tamper proof and that it is not replaced in the future by any other person, even while it is in the court or whether the property has been returned to you. Please ensure that it is tamper proof. Back. पीछे चाहिए. I want to go back. Back. उससे पहले. आप आगे जा रहे हो, पीछे. एक काम नहीं कर रहा शायद. उससे पहले. Okay, so apart from the powers and duties, powers of the inspector, we also have the duties. So is there any other mechanism in which I can go back? Just take it. उससे पहले previous ones, previous. बहुत आगे आ गए. Or you can give me the system I can handle. नहीं आएगा? Okay. No, it isn't functioning. उससे पहले लीजिए. Or you just scroll through the first slides onwards. First slides onwards आप चलिए फिर. Okay. इससे पहले. हाँ बस. So I think we heard about the sampling and how to restore the sample portion to the person from whom the sample has been drawn and ensure integrity of the sample while it is in custody with the officer. I've also spoken to you about the procedure for after seizure. Once you seize, you will have to submit the property to the Honorable Court and take permission to retain the custody of the sample or the drug seized. And this has to be done on priority. And what is the timeline mentioned in the Act? Is there any timeline mentioned in the Act for informing the court? There is no timeline mentioned. Forthwith. It is written as forthwith. So meaning that it is immediate, irrespective of the fact whether this is a Saturday or a Sunday. If it was a Saturday or a Sunday, then I think except for a Sunday, you should actually submit it in the timely manner to the Honorable Court. And these are the challenges. If you had seized a drug on a Saturday, where do you keep the seized sample portion or the containers and goods? Usually, we try to drag it up to Sunday, and therefore the immediate next day you can submit it in the court. So these are all the operational challenges. Bringing it to your office and then taking it back to the court, usually to be avoided. But if it is unavoidable, you should have a malkhana, like the previous speaker has said, where to keep the seized property. Also, it can happen that the seized property is in such large stocks that you cannot take it to the court. So in such instances, what would you do? You would request the magistrate to take cognizance of the matter, or to present their officials and staff, the property clerk, to visit the premises and to seal the premises or take that as a cognizance of offense. Next slide, please. So here you can see that the orders for custody has to be obtained forthwith. Next, please. So apart from the sections, the powers and of the inspectors, we also have the drug rules. So what is it that you are doing when you are seizing? You are actually seizing those goods and materials which are in violation of the law. That is, they could be substandard or they could be spurious, or you suspect them as adulterated. In a way, they are violating the conditions of the manufacturing permission, manufacturing license permission, or the sale licensing permission issued by the state licensing authority or the central licensing authority in the case of, say, blood banks, vaccine. Of course, that is under the joint licensing system. Next, please. So similar provisions have now been well delineated for the medical devices, and here I highlighted a few of the requirements under MDR, that is with the various chapters and rules, including that for cosmetics. Next, please. You have the duties of the inspectors enshrined under Rule 51 and 52. It says the premises license for sale and specially authorized to inspect the manufacture of drugs under Rule 52. Next, please. So as per this rule, you are required to inspect not less than once a year, whereas this is not in congruence with the risk-based inspection rule, which says once in 3 years. Whereas if you are a local area inspector, then the term here is 1 year. Next, please, for inspection. And also to maintain all the records of inspection, make inquiries as may be necessary to detect the sale of drugs in contravention of the Act. Next, please. Nothing is visible here. Slides are not visible. So while they arrange the slides, I would want to explain, like the previous speakers, I think Dr. Joseph, who spoke in the morning session, was talking of what is it that you do when you gather evidence, right? How to gather evidence. Gathering of evidence is the most important for all our cases and proving the offense. And that would require intelligence and common sense. I like those words actually. Intelligence and common sense and evidence to prove our case. Say for example, we have a case, I had a case. It was a complaint from NPPA. You're all aware that state inspectors are authorized to launch prosecution for violation under drug price control order. We are notified under the Essential Commodities Act as well. So I received a complaint, rather my office, that a company is selling a product with a price which is higher than that is permitted under the drug price control order. The manufacturer is within my jurisdiction, and I was new to the area. Though I was an inspector for quite some time, I was new to that jurisdiction because my posting now is at a new jurisdiction. So I went to the manufacturer. My idea was to see the control sample and to see what was the price printed on it as compared to the drug price control order. To my utter dismay, the same batch which was identified by NPPA, the price printed on this strip of tablets is the same as that of the drug price control order price. Meaning that what was in the market had a higher price of the same batch, whereas the control sample had the price very much within the. So this was a ploy by the manufacturer is what I understood, because NPPA also must have had some complaints. The idea is how to get those sample portion which had the higher price. Challenge was that. I could not fathom how I will get that evidence of a higher price product unless and until I go to the market. Right now I am at the manufacturing premises. But I thought, okay, this is not simply a DPCO complaint. Having come here, I will do my inspection under Drugs and Cosmetics Act. I came with the purpose of DPCO, but I went for inspection. So once I started inspecting the manufacturing premises, I found that the analytical chemist wasn't there on duty that day. The manufacturing chemist was the owner of the company, and there's a lot of production happening. Tablets, most of them were tablets. They were all white, off-white, yellow colored powders, meaning that there was no labeling. There was no labeling at all. So those days we did not have, mobile phones given to us. I was using my personal phone. I wanted to record. I was recording. I started recording that none of these containers containing tablets had any identification. The mass mixers, the blender that was there and was operational, was running, had no label of whatsoever. So I tried to record in my Nokia phone. The owner, unknowingly, I didn't know who the owner was. He was a manufacturing chemist also. He threatened me. You cannot record my premises. So I thought, okay, let's not be in loggerheads with him. I stopped recording and started preparing inspection report. Even if I want to write an inspection report, I don't have the batch numbers. I have nothing on hand. However, the idea was to ensure that I make a report, that I had in fact come to this premises with a purpose and this was the purpose of my visit. I have taken, sample portion of the same batch which was in of the DPCO price. It was, I think, riboflavin tablets, which were hardly 2 rupees or 1.25 rupees. So I took the samples, I narrated that in my report. He was refused on white paper that he refused to give me a copy of the book of Form 35. I have drawn these samples and narrated what was happening on in the premises. And while I was preparing the report, that it was in such a bad shape, I'm not going to reveal to him that, these are the violations. I was only gathering evidence. That these are the practices or the poor practices of the company. Ultimately, I had to serve that report to him. He knew that I stopped recording, but I'm preparing the report, which is going to be detrimental to him. First thing, for me, I needed evidence, and that is the inspection report, and I have to go out safely. So he realized that, she is not going to leave me. Looks like he knew me better than me. And I started preparing the report. He arrived with an iron rod. He arrived with an iron rod, meaning that he wants to scare me. And I should get out without writing a report. And that means he's totally non-cooperative. Totally non-cooperative. The idea was, to write the report and then leave the premises, despite the threat that he is giving me. I prepared the report. It was maybe 3 to 4 pages. I simply did one thing. As stated by the manufacturer, these are riboflavin tablets. As stated by the manufacturer, this is what he is manufacturing. As stated by the manufacturer, this is what he is manufacturing. And this is the approx quantities that is lying in the premises. Batch number nil, manufacturing date nil, expiry date nil. And then I went to the raw material stores, finished goods stores, and whatever was there, got it weighed and made a report. These are all the statements without any label. Then records of purchase of the raw material, not available. They are in his administrative office. Record the same. Total non-cooperation from manufacturing front or even at the raw material stores front and the finished goods front. Similar. Completed the report and went back to office safely. We had IPS officers and then narrated the whole issue, filed the report. So the IPS officer said, you should have called me, I would have sent reinforcement staff for you. Somehow it did not strike me that I should really call and seek help. And it was also in the outskirts. The idea was to get out of the premises, but with evidence that these are his practices. And the threatening behavior was explained to my boss, who was a IG police, DG police. And he told me one thing, I advise you to file a complaint or file an FIR in the local police of that jurisdiction, that he was threatening a public servant who came lawfully to do inspection. So next day I went to the police station, filed an FIR. He also gave me reinforcement staff, that is my colleagues, that is ADCs as well as DIs. We went back on the next day. After filing the FIR, I proceeded to the manufacturing premises as a team. We knew, later I came to know that he was an accused even in NDPS cases, not convicted though. So the DG also helped me with the police who was witnessing what we want to do. We went back the next day, and the next day is even worse. Huge quantities again getting manufactured without any records. No records. Now with the help of my colleagues, we seized the entire quantities of stocks which were lying in the premises. For me, which are the BMRs? whatever I say, he's saying this is A drug, B drug, C drug, and where are your BMRs? Today, the next day, he hit upon a plan saying that my BMRs are under preparation. My BMRs are under preparation. So we gave him time, you prepare your BMRs. He prepared the BMRs. And the batch numbers were there. And he says the batch number correlates with this, which are getting manufactured pertains to this. So we just simply took the records of under 22.1 CCA after giving an 18B notice. Because he's a licensed manufacturer, I gave him an 18B notice and took the records under 22.1 CCA, seized the drugs and submitted to the court. There were such huge quantities, I submitted to the court. I draw this after drawing sample, of course. The samples were sent for testing. They all turned out to be standard quality. They all turned out to be standard quality, meaning you can't detect those impurities, correct? You can't detect those impurities, but basically they pass the identification test and assay. Now, the next thing that I did was, I went to the wholesale Dawa Bazaar market and requested the wholesalers and retailers who buy from this company to give me the details of purchase of various products that I had seized over a period of 1 year. So the batch numbers that I had seized or rather sampled were already sold actually, and they're already in the market. So I'm very lucky. Here are the records which say that they're yet to be distributed and the whole stock is lying in the premises which I had seized, whereas the market has the same batch number which is already in the market. So this actually took me quite some time to prove, but it gave me the idea how the DPCO violations occur. I make multiple batches with the same batch number, but record only for one batch of a limited quantity, and the rest goes without any record. So these were the practices that this manufacturer had evolved. There were no records. The batch number, wherever you go, the batch number would be perfect. I mean, the batch record would be perfect. There could be multiple batches of the same batch number manufactured over a period of time. If you took the annual records of batches that he had manufactured, it could be 5 riboflavin batches, but 5 of 1 lakh each perhaps, but marketed almost 5 to 10 times. This I took the purchase bills of only one wholesale bazaar, where there are multiple wholesalers. It could be there are wholesale bazaars everywhere across the state and other states as well. So this was the modus operandi, and while we were seizing in this manufacturing premises, we took the assistance of a police constable. The police constable there was only for a protection, because the previous day this is how he behaved, and today he should not be behaving the same with the regulatory officers. So he was there. The police was there. He was only a constable, but he was there to assist us and to prevent the manufacturer from, harming us or hurting us or not showing us the records. He has no role to play in signing these records. The seizure was absolutely done in a free and fair manner by explaining to him that this is the purpose of the seizure and he has to share with us the records of purchase as well as sale of the raw material. We explained to him everything and then put it on record, and it was in a very transparent manner. I filed the charge sheet in the court. Before even I could launch the charge sheet, file the complaint rather in the court, the manufacturer took the reports of analysis and went to the High Court, saying that the seized material is of standard quality and therefore has to be returned to me. So I did not return the material. And time was running out for me because the High Court has already given the judgment. So it would be like I will be risking the court's ire, and therefore my senior officials and IPS officers said you can approach the Supreme Court. After the High Court, it is the Supreme Court. And why we do not want to release these stocks despite being standard quality on the face of it. The reasons are, like I said, the batch records are not true representative of what were actually being manufactured, and there could be impurities rather, in the manufacturing, contamination and cross-contamination, which are very difficult to detect, and this is absolute violation of the then Schedule M. So I filed a case, I rushed to the Supreme Court, presented my case here, and the court, the Apex Court, gave a judgment. It was a double bench. It gave a judgment that the products were being manufactured absolutely in violation of the requirements under the Drugs and Cosmetics Act, and you don't need to release these stocks. So it was not simply standard quality or not standard quality, but it was much beyond that. And I took that responsibility to come to the Supreme Court, file it in the Supreme Court, and ensure that the stock is not returned. And that was the first court judgment of Andhra Pradesh, of the Apex Court for the state of Andhra Pradesh. And I was here for almost 15 days at Delhi to present my case, and it was a big relief for me that the drug was not to be returned to the manufacturer. This all happened before even I could make a complaint in the lower court. So he approached the High Court, I had to approach the Supreme Court. So these were my little experiences that I had, and rather this is the first case for the state of Andhra Pradesh. With this case, I started investigating how did he get these APIs, which had led to these so many formulations being manufactured without records and also being sold without maybe sale invoices. So this led me to another case where I found huge quantities of API being manufactured totally without a license. That triggered me to visit a wholesaler, and from that wholesaler, while investigating that wholesaler, I realized it was not just paracetamol, but there were several other drugs he was purchasing, and that led me to, I think it was guaifenesin, and yes. And he did not have any manufacturing license, and that was being manufactured in tons. So you can see that you should be, you should use your common sense. First thing. I started with a DPCO case, went to a Schedule M violation, finally proved that, this is violation of the conditions of the law for this manufacturer, took further investigation up and landed up to another manufacturer at another manufacturer where there was unlicensed activity. That was not my jurisdiction. So I assisted another officer for seizure of that drugs and huge quantities. Even that case landed in the court of law, that is Supreme Court. Even that case landed in the court of law because that was an API, it was an active pharmaceutical ingredient, and there was no proof of sale to pharmaceutical manufacturers. That drug could also, I don't think it's guaifenesin, it's some other drug, I'll let you know, but that could be used even in nutraceuticals as well as a drug. I think it's glucosamine, sorry. It is glucosamine being supplied to pharmaceutical manufacturers as well as to food or nutraceutical manufacturers. We took up this case, and the Apex Court said even if there was no proof of sale, manufacturing a drug labeled as USP or BP in such huge quantity, it requires a manufacturing license from the State Drug Control, and it did not have it. Therefore, that was also a huge and a big case. So use your logic, use your common sense. You may be put into several situations, but you will have to take your case forward and prove your case. So there was another instance where we went to a hospital. I was an assistant director, I went to a hospital, which is a government hospital for oncology. And there I found, I had inspectors with me. We found formulations, a tablet formulation, where the manufacturing license number was not visible, was not at all there on the formulation container. This was purchased by the hospital, and ultimately it happened that the manufacturer is also from Andhra Pradesh. We landed at the manufacturing premises, and the manufacturer denied, saying that I don't have the records of this manufacture, but I sold this product to the government hospital. Without having manufacturing license, you have sold a product to a government hospital. So when we identified that the label does not contain the manufacturing license number, immediately we took copies of the purchase bill and the tenders. It linked to a wholesaler, and that wholesaler is also the same manufacturer. So together, what they have done, without obtaining manufacturing license, they purchased the capsules of another brand, of another company, removed the labels of that manufacturer, put them into containers. They looks like they were in blisters, and now he put them into HDPE containers with his label, but very nicely, cleverly, did not put the manufacturing license number on the container closure system and sold it to a government hospital. Now for me to prove that in fact this was manufactured by the company, we did not have any records. So he only gave it in writing after giving a notice under section 18A and B. He gave it in writing that he purchased it from the open market, and unknowingly he has relabeled it as manufactured by him without the manufacturing license number and supplied it on emergency basis to this oncology hospital. The case went on and on. We could not find out what is the source of the API. We were not getting the batch manufacturing records as well, because he has not even done any manufacturing. Now for me, I have to prove that in fact he purchased the API and he formulated it. This was his story, that I purchased it from the open market and put it into containers. So what we did, knowing the drug, we tried to look at the internet and see who could be the supplier of this oncology API, and they happened to be in Karnataka. By chance, we contacted them, mailed them, and asked if you had supplied this API to this manufacturer, and he gave us the reply within 24 hours. He said yes, he has supplied the drug. The drug is thalidomide. The drug is thalidomide. So once you prove the supply of the API in XYZ quantity, it should turn out into so many capsules or tablets. So what happened to the remaining tablets and capsules? He exported it. Partly he made these capsules and supplied to the government oncology hospital, and the remaining he has exported it. See how your alertness can lead you to this type of crime. And everybody leaves a trail here or there. In this case, he has not mentioned either the import license number or he has not mentioned the manufacturing license number. This is what is expected of inspectors. Be vigilant, be cautious. So while I worked in Hyderabad office of CDSCO, also we faced this challenge, and I received a complaint saying that a manufacturer in the jurisdiction has been violating the provisions of Schedule M and is manufacturing drugs as per his whims and fancies, and even this was an oncology unit. I made a complaint 3 years ago. Your people have inspected and found that there is no violation of Schedule M. But I am sure that he is doing some malpractices. This was the complaint which came through mail. And looks like he was a foreign citizen or he was abroad. So I got the file back from the archives of the Hyderabad office and found that in fact there was an inspection and there was no violation that was observed, and the file was closed. However, because he's repetitively sending mails, I asked the inspectors of CDSCO to inspect the facility. They in fact had gone for WHO GMP and it was same manufacturer. I said, you will have to go back and see what has happened in this premises. And we found that the APIs that were being used for manufacturing of the formulations were imported as per the label, but without import license number. There was no license number of import on the containers, bulk containers, and these were being used for formulation. So we found out the violation, isn't it? That is, without any import license number, and then we tracked the case, we seized the materials, and it got connected. He says that it was purchased from Ahmedabad and Mumbai. Of course, when we wrote to these two offices, we could not connect the API linkages or the wholesalers for this API. Only in one case we could find that the manufacturer was situated of API was situated in Andhra Pradesh. We investigated that and he denied supplying the API to this manufacturer. So where are these APIs coming from? That was the big question. Now, seizure of the API is one thing, but also proving manufacture, sale and distribution is important. What we did, the same products were sold by the manufacturer to wholesalers and retailers in Bangalore, and we went to the extent of sampling as well as seizing not only the APIs but also the formulations or proving the sale of the formulations manufactured using these unapproved or unlicensed APIs. So this is the evidence that would be clinching when you present it in the court. The procedures of the court, the number of days or years the case may drag on in the court is secondary. But while you gather the evidence, it should be, end to end to prove your case. Manufacture, stocking for distribution and sale. And in fact, a patient has been harmed. If you prove all these together, then your case is not today, even later, you would win your case. So I will also end by saying that how to gather evidence will come with experience, but always remember what the law says. That is, what is the section saying and what is the rule saying. The section says again and again, manufacturing huge stocks or manufacturing without a license or distribution without a license is violation of section 18C. Prove every part of it, whether it is whole human blood or whether it is blood product or whether it is medical device or whether it is a drug. So I did this even in the case of a blood bank where I knew that it was under suspension and came to know that it reopened in another premises. We suspended the blood bank for not having the facilities and the infrastructure or the technical staff. Because the license was suspended, he shifted his equipment to another premises, and that is where he started continuing his works. This place I raided along with my inspectors, and we proved that not just whole human blood but also blood products were being manufactured and sold. So how can you prove the sale of whole human blood or unlicensed products, that is in this case the blood products? So what we did was found out the prescriptions for RBC, pediatric bags, and seized the prescriptions. We also seized the equipment that were used, including ELISA, washer, incubator, a few of the equipment to show that there is unlicensed manufacturing activity occurring here, and also the prescriptions that these products were being sold. How to prove that in fact these were sold? Only I found a prescription, but I need to prove that these unlicensed products were sold. So with the help of the prescription, we investigated various hospitals. if they had purchased, if the caregivers had purchased the blood units from this hospital, the purchase bill would be with the consumer. But I need to prove that the blood was or the product was transfused to the patient. Therefore, we requested the hospitals to give the hospital records of transfusion. And luckily for me, in the hospital records, the label on the product was affixed on the transfusion record. So now I know that this blood bank had supplied unapproved product and it was transfused. So who is my witness now? It was the physicians also. It was the physicians who had transfused the blood apart from the manufacturing activity that I found, including labels for blood products. So the clinching evidence is that he was manufacturing at an unlicensed premises, proof that this room was not under the previous license, but this premises is owned by somebody else, and also that the equipment have been shifted or kept in this premises. So we seized everything, proved the case, and I think that is the first judgment in the whole of the country which gave him rigorous imprisonment, the owner of this blood bank, for 3 years. So this is the first of its kind where we proved end to end that, there has been a violation. And all this happened without a medical officer in place. So the owner of this blood bank was also a technician previously, and he was running the show without a medical officer. You can see the amount of violation that has occurred, including transfusion of unapproved product. If this is the way you investigate, I'm sure you will be able to bring the case to conclusion. So the presentation actually talks of, the various provisions and your inspection powers, the risk-based inspections, and the nuances or the differences between the various forms for drugs, medical devices. I'm sure that will be used by you. And I try to highlight the differences between the medical device rules, and I like this provisions under the medical device rules, which says that inspectors are also responsible for review of dossiers. Somehow it is missing in the drug rules, but I'm sure you are reviewing dossiers. So the rules, once we frame the next time, should actually include this. This is the one, 77. Review technical dossier of medical devices furnished with the application under these rules, right? So without review, you can't go for inspection rather, even for drugs, but this was very well specified under the MDR. So for cosmetics, I'm sure you're aware the differences for manufacturers of cosmetics and the inspections. CDSCO has no role, correct? Should CDSCO be a part of the joint inspection for cosmetic manufacturing license? What does this rule say? Understood the difference? It is not essential for us to do the grant of license inspections. It is only by the state government. Whereas here, when directed to do so by Drug Controller India or controlling officer, he may discharge his duty. right? But on the contrary, I think for you have laboratories for cosmetics, private testing laboratories for cosmetics, that is joint inspection. Please understand the difference. And here I try to capture the sampling, rules for sampling, reporting. No, that nowhere it is written so. That. Hmm. Hmm.
They are asking that every time they are asking original, whenever the sample fails in multiple samples in the same case, two products are failing, means they are asking the original copy to add the code. In another case, because it's a different, they are also asking the original. So a single product for each form. That will be comfortable.
Understood your statement. And I think that is what has been done by CDSCO. That is, you prepare separately the Form 17 for each of the samples, but that has never been the practice for the state. Your statement is, what if the original is required in multiple cases, what do we do? So you have to make a statement. Usually, if it is the same manufacturer, if I draw the sample from the same manufacturer, then it would be a single complaint and they fail. But if you're drawing multiple manufacturer samples from wholesale or a retailer, it could be independent and different charge sheets and complaints. So you can use that procedure, but there's no harm in informing that the original had to be filed in other case. You can, and the court would admit that. No problem. The thing is, you will have to explain to the court that this is a certified copy. The original has been filed in the other court. Yeah. So confiscation, I would like to inform you all that confiscation is not under the purview of the inspector. The difference here is that it is once proven that, it is illegally manufactured or unlicensed activity, or it is in fact a spurious drug. It is only the court. Once, for example, I seized in the case of a blood bank, I seized the equipment. What happens to the equipment? The equipment is now the property of the court. And if the court gives order for destruction, it would be at the expense of the accused, because the judgment is in that favor. Or even if he is not accused, the court may direct it to be destroyed. Until then, the property is under the custody of the court. You are only a temporary custodian of the material. So this is the legal sampling format, the various forms that enable you to distinguish. Try to capture here basically for sampling, but also here, this is the one for Form 15, 16, and for medical devices. I hope this would be useful for you, and rather you must always be using it. So these do's and don'ts are a very simple thing that I have mentioned here. Like the other officers have also said, principles of natural justice have to be followed. You will have to explain the reasons for keeping the product under Form 15 if you want to freeze the stock. And the question is, very oftenly asked question is, do we need an inspection report for while we sample? So what would be your answer? If you're sampling, if you have a Form 35, you would write that I visited this premises for so and so purpose, I drawn a sample. So always think that, a spot report or an inspection report would help you. That in fact you visited this premises and you had come there and you were there during the day or whatever the time, and you had drawn the sample, and these were the conditions under which the manufacturing activity is happening. So always make it a habit, even if you're drawing a sample from a wholesaler, try to enter that your presence in Form 35 or if that is not happening, prepare a separate report, give him a copy, keep a copy with you, and then your actual case starts, right? So you will never know whether this sample would be SQ or NSQ. And always be prepared that your report will land in the court of law. Whether it is manufacturing site inspection report or a wholesaler or a trader's inspection report. Always remember, when you put something on paper, on record, you are a gazetted officer, and that this report is likely to take it to be submitted to the court, including a sample portion, including a sampling portion. So do your duties diligently. These are what is specified in our law. We are a technical law, and be vigilant and go fully equipped with the knowledge on the, not just the sections, but the rules. To prove that this is in fact a violation, you could be saying that there is a violation from GMP perspective and whether it would lead to conviction. So various questions are, has any NSQ been proven, yes, NSQ, and final verdict is, till the rising of the court. We have seen cases where it is simply until the rising of the court. Don't go with that feeling. Prove your cases that, like I did in my case, started with DPCO, landed as DNC Act, under the DNC Act. The court actually observed that these products were manufactured in violation of the good manufacturing practices. And there is a risk of contamination and cross-contamination, and therefore not to be returned to the manufacturer. And there is a case against the manufacturer for violation of several other provisions. So whether a GMP violation has led to prosecution was in my case, and which actually proved that, every section, every rule is connected to the sections. And if you read everything from the rule perspective alone, it will not make sense, but always connected to the sections. I'm sure you are aware of Rule 74O and 78P. All these put together will help you do a better job. Understanding of the rules and regulations is very important. Thank you for your attention.
Thank you so much, Madam, for your wonderful talk. Now the session is open for the question and answer. We can take quickly few questions. Any question? Yes, Deepak. Use mic.
Want to know about, is there an SOP prepared by CDSCO how to make an arrest? Is there an SOP or guideline how to go about it?
You're asking question to me or to the speaker? The madam will.
To the madam.
So yeah, I think Enforcement Division is working towards it, and there is also a committee constituted for it. You can see that it is part of DCC also. Arrest procedures. So the question is, why do we arrest? I think I have not arrested so far anyone, but
training is, this training is for how to make an arrest.
I agree with you.
Yes, sir.
So what is the purpose of arrest? Can anybody tell me? What is the purpose of arresting a person?
We usually go for raids or something where during raid we actually need or investigations, during raid and investigations.
Yes, so what
we come across the purpose of arrest.
I agree. So what is the purpose of, reducing the liberty of a person? What is the purpose of that arrest? If anybody can tell me. It is basically to elicit some information. It is basically to elicit some information.
Yes.
Right?
Yes.
So can't we do that through Section 18B or Section 18A notice?
In case of spurious and unlicensed?
It is 18A. Notice is issued under 18A. Notice can be issued under 18A. His reply can be obtained on the spot. And then you proceed for further investigation. This was what we had done. It is not that we don't arrest. There are colleagues who have arrested manufacturers who are unlicensed and not within the state of Andhra Pradesh. The offense has occurred, been identified in that particular state, but the cause of offense has occurred in another state because manufacturers can transport the materials across the country. Correct? So what Andhra Pradesh has done was, with the help of the police, proceeded with the evidence that they had to say, I think it was in Baddi or several other places, proceeded there with the help of the local police and the Andhra police, arrested the person with the help of the police to prove that in fact he has manufactured this unapproved or maybe adulterated or spurious drug and then linked the case. So this was done with the help of the police to elicit an information. In this case, it was said, in this judgment of the Apex Court, it was said that the inspector also, drug inspector also has the powers to arrest, and that is why this is happening. All the discussions today are happening, how to arrest. And your question is, has CDSCO prepared an SOP? And I'm sure the enforcement division, the ADC is here, she must be aware. You can answer his question.
We are preparing the SOP. First, we just want that everybody should be known for the arrest procedure first, and then we are working over the SOPs. Once the training will be over, the SOP will be finalized.
Yes, this is part of it. Yeah.
Thank you.
So always think from that angle. Why should we arrest a person? Can we elicit that information through other means? It could be through circumstantial evidences also that you can proceed, and financial evidences also that you can proceed to the subsequent person in the chain, right? So arrest is one means of eliciting information, is what I understand. After that, and bringing it to the knowledge of the court. Later you will be let off on bail and you continue with your investigation to prove your case and to file a complaint. And I think that was the very question that your colleague had asked the previous speaker. So I don't have a complete investigation, but I'm arresting a person. And the police has an FIR procedure. What is a procedure that drug inspector has to evolve, or what is a method to intimate the court? Right? That was the question that was asked by your colleague. The charge sheet is still, evidence is still being collected. Meanwhile, you arrest this person. In fact, you are arresting the person to gather more evidence, to elicit information, right? So prior to that, all procedures of BNS would have to be followed, but the previous speaker has said there is an FIR procedure on an individual that has to be followed by the police, whereas for a government complainant like us, what would be the procedure? Is there a format? So all this would come up with, further thinking and brainstorming, and they also spoke about digital evidence. So I do not know how many of you have used digital evidence in the court. I only heard Rakesh speaking that he has used the hash number also to compile this data. But also it is like you can take paper-based evidence also. Under 22(1) CCA, you can take certified copies of the output of this. If it is huge and humongous data, then obviously it has to be through a digital means. And digital means, once you submit it to the court, then a cloned copy also has to be given to the person from whom the material has been seized. If you have seized this material, you want to submit it to the court, it has to be returned within 20 days, right? This digital evidence also. Or you take a cloned copy, treat it under 22(1) CCA as certified document or copy of digital evidence and submit to the court. So you will have to read it along with the sections of our existing laws. Thank you.
So with this question, we are going to close the session. Thank you so much, Madam, for your wonderful talk. And I will privilege to present a token of appreciation to Madam. Please join me while presenting the memorandum. We are going to break for lunch now. How many minutes you want? 30, 35, 40? 45? Okay, be back 2:15. Enjoy your lunch.